Someone make it make sense.
Probably a couple.
Good evening. I don't know why I felt like saying that like Count Dracula, but you know what? That just happened. So we are here to talk with Bryan Kohberger, and I'm happy that it let me go live. I'm happy that I am live. Hopefully you guys can hear me because we had some issues yesterday, but seemed to get those sorted out with StreamYard. So do let me know, though, if you guys can hear me in the chat. Pretty please. So, yes, so we are here. Let me play my slideshow here. Excellent. So we are here to talk about this hearing, part 2 of the hearing, the motion to change venue. But there's been a slew of court filings since the hearing, and just so in the past couple days, basically. And they're all pretty much regarding the motion to strike the death penalty. So I want to cover as many of those as absolutely possible. And I'm going to let you guys, as people start filtering in, decide what you would like to start with. Would you like to start with the hearing, or would you like to start with the court filings? And just to refresh everyone's memory, where we left off with the hearing was we were on Dr. Bryan Edelman's direct examination, and we were about to get into his PowerPoint presentation. So that's where we were at and where we will pick up with. So shout out to Iowa's backyard. Yeah, the stream went to private because it was messing up. And so you could hear me, I guess. That's wild because no one else seems to be able to hear me. If you're referring to the one that went to private, that was the one that I put it to private so that I could delete it, but I wanted to make sure that I could hear it, like go back and listen to it myself to see what the issue was before I deleted it. But obviously, from the feedback I got was like no one could hear anything. So that's why I ended it and set it to private and then subsequently deleted it. But glad you were there. And if you could hear it, then that's wild because you probably were the only one. Glad you guys can hear me though. Shout out to Random Girl. Shout out to Iowa. Backyard Cam. So yes. So let me know what you guys want to start with. I guess what I'll do is I'll go ahead and just start getting into this PowerPoint, and then we will take it from there and kind of see what people want to do. But yeah, we do have these documents are really interesting. So let me share my screen here. Okay, excellent. There we go. All right, cool. So here we are. We're right at the beginning of his PowerPoint presentation.
Thank you for that, for the patience. I think we have it now. Will you give us a or an overview of what we're going to talk about today?
Yes. So the presentation is broken down into 3 parts. So the first part is just kind of a cursory review of some of the social science research, some of the basic general research, foundational research, and then research specific to pretrial publicity and juror decision-making. And then to get into the actual.
Right, just like I'm just reminding myself and all of us that I'm going to put it on 1.25 like last time because it's okay. We can usually
change of venue analysis, which focuses on the media coverage, so the extent and nature of the coverage, and in addition to whether or not that coverage has had any impact on the jury pool. So that really gets into the survey. And the last part gets into the unique challenges that cases like this pose when we talk about jury selection. So is what you're an effective remedy in cases like this, where there's been a lot of media coverage and people have a lot of knowledge about things.
I heard you say cases like this. What do you mean?
Sorry, when I say what?
Cases like this.
Oh, cases that have a lot of media coverage. So in a normal case, like a car accident or something like that.
Is that supposed to be him? Is that supposed to be him? What? That's not him. Weird.
People come in, they might have general attitudes about drinking and driving, but they don't have case-specific attitudes about this person that are well-developed from information I know about the evidence and the person and so on. When you have a case like this, people come into the courtroom with case-specific attitudes that are well-developed and based on, it could be emotional information, it could be evidence that they already have read, seen, or heard. So they have very well-developed attitudes. So that's a unique thing because they're no longer blank slates when they're hearing evidence. They're confirming what they already know, as opposed to jurors who don't know anything and are learning and building attitudes and knowledge structures as they go.
All right, let's go to the background.
Yeah, probably AI.
Why we do this, why this matters.
Yeah, so there's decades of research in general documenting the impact of pretrial publicity on decision making, and it kind of falls into two areas. So there's what we call field research, which is kind of similar to like a change of venue survey. So people are exposed to pretrial publicity in a naturally occurring setting. I read the newspaper, I watch it on the news or on the news when I'm cooking dinner, whatever it may be. And so we see natural exposure and we're able to assess the impact of that coverage on pretrial opinions. But there's some limitations to that. We can't really learn how pretrial publicity impacts decisions, and we can't really learn the types of pretrial publicity that are most impactful, and whether or not remedial measures like an admonition or voir dire mitigate the impact it has. That's where experimental research comes in, because it's a controlled setting and we can test things like what types of pretrial publicity are most prejudicial. How does pretrial publicity impact decisions?
I have to say, let me pull my banner down. Could we not have done a little bit better with like this PowerPoint? Like, really? I mean, I will just say for free, the templates it gives you are way more exciting than what we're seeing here. Anyway, just saying.
Things like the remedies work.
A little bit.
Do you have an example to help me understand maybe the difference starting with field research?
Sure. So the one we're looking at here is one of the earlier pieces that was published, and it looked at 3 cases that were high-profile cases in California. One involved the murder of 2 police officers, I think it was in Yolo County, and then the murder of a dental hygienist from a prominent family. So it was the status of the victim was important in that. And then I believe the third one was a rape of a young girl. So they did 3 cases, and they did surveys to assess the impact of that media coverage. And they learned a couple of interesting things. So they learned that people who consume news, whether they watch it on the news or they read the local paper, develop more case knowledge. So the more often I follow the news, the more likely I am to have detailed information about that specific case. So there's the first relationship that we look at. And then the next thing is case knowledge impacts presumption of guilt. So people who have well-developed case knowledge, they've read a lot about it and they know a lot of detail, they're more likely to think the defendant is guilty. They're more likely to have an opinion about that. And that stands out as more important than a host of things. They looked at gender, education, attitudes towards the criminal justice system. And ultimately, case knowledge was 10 times more impactful, more important than attitudes like towards the criminal justice system. So it wasn't something like, I'm just a pro-conviction person who tends to favor the government and think people are guilty. It was far more important than that when it came to these attitudes and opinions they developed.
It sounds like the field research has been important in your profession.
Yes.
Fair to say?
Yeah.
Help me understand what experimental research is.
Yeah, so these are more, again, traditional studies where we are able to control. We can look to see, maybe we're testing to see what types of pretrial publicity are most impactful. Maybe we want to know if voir dire is an effective remedy at mitigating the influence or impact. An interesting study someone recently did was looking at the set-aside question. And they were looking to see if you did something like normally what happens to jurors on the spot, it's just like, what do you know about the case? And it's kind of like on the spot, I need to think about it and try to recall everything from memory and start it out right there. So the remedy was, what if the person was given time to write down everything they know and think about it? Think, can they really be fair? And then come back to them and then ask them again. So they were looking at that as a remedy. So that would be an example of an experiment. And like globally, what we find is exposure to pretrial publicity impacts perceptions of guilt, and it influences the defendant's credibility, likability, and sympathy towards the defendant as well. And overall, most of the research shows that judicial remedies are not effective. We talk about admonitions, so like the judge telling the jurors are not allowed to consider media coverage, they have to set that aside. Voir dire, kind of like I was mentioning before, those don't mitigate the impact of media coverage. Delay is another one. Sometimes there's a long delay between when.
I mean, if you were a judge, this judge or any judge hearing this, I mean, it's like, this shit is like, I don't know. I feel like if you were a judge, you'd be like, well, then what are we fucking doing here, right? If judicial remedies, okay. Like, obviously there's high profile cases we hear about all the time, right? And through the voir dire process with juries, we learned that what matters is, not necessarily how much information they know, but is it, what's their level of bias going into it, right? Anyway, if that would be the judicial remedy, the biggest one, right? If that remedy does not eliminate pretrial publicity effects, then like, what do we just say, just throw out the entire system? Like, you know what I mean? Like, it's like, what do you anyway, because you can't just take every single case and move it to a different, venue, for a myriad of reasons. Anyway, it's just, again, it's like, this is the problem. It's like, if you really lean into that everyone's biased anyway, implicit bias, and there's nothing that can be done, blah, blah, then it's like, well, then what's the answer, man? So I don't know.
Someone reads the coverage and we're going to kind of do the experiment to see if that mitigates the impact. So overall, those are the key findings and takeaways from the experimental research.
All right. You have a slide in here called, I'm not going to say this word correctly, pot hour and singer. What's this about? How is this important?
So this is, again, just an example of some of the research. So in this study, the researchers recruited people who had been excused for jury duty, so they were at the courthouse. And they were put into 2 different conditions. So in one condition, the experimental condition, they read an article, and that article contained information about the defendant. It was a criminal record. And it also included a retracted confession. So they're looking at something that's inadmissible. It wasn't going to come in, I believe, in the story. And the control group read the same article absent those 2 pieces. They didn't mention anything about the criminal past, criminal record, or the retracted confession. And what they found, if you go to the next slide, is that there was a significant effect. So those participants who were in the experimental condition, the ones who had been exposed to the background, the criminal background information and the retracted confession, were much more likely, I can tell I'm talking too fast, were much more likely to convict and perceive the defendant as guilty compared to the control group. So that was a significant effect.
That seems like a pretty high percentage. This is an experiment with 2 otherwise equal groups of people, some exposed to negative publicity and some not. And almost 30% of the people in that experimental group would have voted to convict just based on that difference alone.
So 28 percentage points higher. And again, it's a controlled study. So they're controlling for everything. So the only variable really that should be, that's impacting is the fact that one group heard this negative prejudicial information, the other one didn't.
Seems like a high.
What's that?
That seems like a high amount.
Well, it's a significant finding. It's statistically significant.
All right. Let's talk about
picture.
pretrial publicity.
Look at that picture.
How does it impact information that you might get in check?
Yeah, so we already heard about this a bit in terms of this selective process for filtering information. So the one that really is significant for me that stands out is the belief perseverance research.
Right.
I'll tell you why. And like it was mentioned, so a common study would be someone would read an essay. For example, there might be an article about why risk-taking makes you a good firefighter, and people who are cautious that's not a good characteristic. And then someone else might be the exact opposite, where they're implying that cautious people are better firefighters than risk takers. And then they're asked to write an essay, and whichever one they read, they're more likely to write to support or write an essay that's consistent with what they read. And then later, when they're confronted with information that disconfirms whatever they had read and written, they're resistant to change. So we see that in our everyday lives quite a bit. And the thing that really is significant to think about is jurors who come in as a blank slate in a normal case, who haven't been exposed to media coverage, have no opinions or attitudes that are specific about the defendant, about the evidence, about guilt. And they're just processing evidence in a controlled setting through direct examination and cross-examination. The rules of evidence apply. So they're learning.
I don't know. First of all, I think it's really funny. They must have done like a search for a picture of fitting a square peg in a round hole, because I think that's what we're looking at there. Anywho, I don't know, man. It's like, well, again, what he's saying would be the ideal, right? Where like jurors that have no pretrial publicity, know nothing about the case, they come in as a blank slate, is what he just said, right? They have no opinion, blah, blah. But I don't know. I would push back on that. Again, not that this helps anything, but to say that I think a lot of people, like in the country, unfortunately, now I'm not saying they would make it past voir dire, right? But a lot of people, they might not know anything about the case, but it's very common for people to think that because someone is a criminal defendant, it means they did the thing, even if they don't know anything about the case. So anyway, I just wanted to make a note of that.
and they're developing opinions, they're considering the evidence for the first time. That's the ideal situation. In a high profile case where jurors have been exposed to a lot of coverage and they end up serving, they already have well-developed attitudes about the defendant. And so opinions of the defendant, they have well-developed attitudes about guilt, for example. And they have case knowledge that they've already been exposed to.
I'm just push back on where, like, again, I think it depends on the type of publicity too, because I would say, right, and you guys let me know what you think. I mean, those of us here who are in the LawTube community or LawTube adjacent community who watch trials and learn about trials and want to be educated about the judicial process and the law and our rights and all of that, you know, I would say that while yes, I mean, I don't know, this is why it's a tricky thing. Like, while yes, we might know more about a certain case or certain cases than our next door neighbor, let's say, right? That there's pros, like there's also there's good part to it, which is that, you know, we also, I would say, might even be more readily able to give the presumption of innocence better than, again, our neighbor, right? Because we've learned so much about this process and how it works. And we've seen cases where people are actually like factually innocent, right? We've seen cases where the defendant's rights are being completely trampled on. We've seen absolute disasters like Karen Reed and others, you know? So, and for example, also we might appreciate better the importance of good defense attorneys and, you know, the defendant's Sixth Amendment rights better than our neighbor. Again, I'm just using that as like a compare, like by our neighbor, I mean like a random person, you know? So I don't know, like, I guess that's where it depends kind of like what sources you're talking about. Like if you're talking about people that don't really know anything about the legal process, but are just seeing videos on TikTok where people are like, someone's guilty. Like, yeah, that's not good. Right. But like, I don't know, that's where it just, there's such a huge variety and just, you know, in terms of what it is that people could be exposed to. But I think that it's important to make the case that not all exposure is bad exposure in my opinion, you know?
Right. In a controlled setting. So maybe it's information in this case about cell tower data or information about a vehicle being seen on video or what the results of DNA tests are. And it's not under a controlled setting of direct examination and cross-examination and another expert from the defense side where they weigh all that. It's in the context of a news story. You know, there's editorial, there's public personalities, it's Nancy Grace, all the sensationalism around it. So they're being exposed to all that, but they're also getting the information, the evidence within that context that they're going to hear at trial. So when they hear that information, it's not new, and they're not considering it and weighing it as a blank slate. What they're doing is just activating the beliefs and the knowledge structures they have, and it's just confirming what they already know. So one side is just giving you the information you already have, which strengthens it, and it makes that information more accessible in memory and so on. And then the other side is giving information that is attempting to disconfirm what I already know and believe, and it's scrutinized in a very different way. They're much more likely to reject it, they're much less likely to attend to it, to store it in long-term memory. And it's really shifting the burden. So now the burden, whether intentional or not, is shifted on the defendant to change that juror's mind. And that's what we see when we talk about a filter, like our knowledge is, you know, our impressions serve as a filter for processing new information. So it's really important to think about putting yourself in the shoes of the juror and what the task is and what that's like when you already have all this information compared to a jury who doesn't have any of that information.
I'm going to pause this real quick because this is just getting all of my thoughts going. And I'm actually want to kind of pop over some of these documents because it's kind of relevant to what they're talking about here. We're like in my mind, I'm thinking like after I had the last comment I made about, you know, it's not always bad to have more information. And I'm thinking like, you know, knowledge is power, right? You know what I mean? Hold on, let me pull something else up here real quick. And I was thinking about how, you know, because he was giving the examples of like Nancy Grace and sensationalism. You know, I personally don't watch any of that. Obviously, I just cover it basically, you know, and it's like my exposure is like the hearings where like Ann Taylor's fucking killing it, right? Like, and honestly, like, again, even when he referenced, like, for example, the Elantra and the cell data, my mind automatically, my association with that was the last hearing they had maybe like 2 hearings ago, where they went over a lot of that. They had like an evidentiary hearing, and they brought in like Brett Payne and stuff, and they had like the cell phone expert dude, and like Ann Taylor made a lot of really good points. Like in my mind, I'm like, me having followed this case, you know, if the defense wants you to be on their side, I would say that if anything, like they do a really good job if you're following the case in terms of, again, like the hearings, the court documents, that type of thing, right? The public record, and actually looking at it objectively, they raise a lot of really good points. But that's because she's doing such a great job. Ann Taylor and, you know, the other defense attorneys as well are doing such a great job. So kudos to them. Shout out to them. But let me pull up our slew, as I say, of documents here, because let me see if I can even find where's the first one. Okay. There's like a billion. Sure, I'm going to just pull them all up. So we'll have like a bunch of tabs here in just a second. Let me just count them and make sure I have it all. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. So there's like 14, but one of them I didn't bother to do because all it is this announcing that they're going to have expert witnesses for a hearing. Pull this over here. What is my computer doing? Computer. Wait, what? What is it doing? Hold on. If there's no sound, I'm still here. I'm just pulling up all these documents here. This one, international law. Okay. Okay. Here, let me share my screen. We'll count them together, guys. Okay, hang on. So, okay. All right, so let's make sure I've got, so 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Well, wait. Let me do it this way. Okay, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Oh, it opened this one twice. Oh my God. Well, now I lost count. Okay, is it 13? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. I think this is all of them. Okay. Well, I don't know. We'll get through all of them anyway. We're gonna do our best, guys. Okay, but I wanted to at least, this is really interesting, I promise. So, all right, here we go. So let's start with this first one here. So this is motion and memorandum in support to trifurcate the proceedings and apply rules of evidence during the eligibility phase. Okay, trifurcate. Cool, right? All right, comes now, blah, blah, blah. Proceeding with a bifurcated trial in which non-statutory aggravation is presented without the rules of evidence being applied will result in a violation of Mr. Kohberger's state and federal constitutional rights, including the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as Article 1, Section 6 and 13 of the Idaho Constitution. Argument. I love it when they go right to the argument, right? Idaho's, okay, this is really interesting, I feel like, okay? And, you know, some of this we might know from other cases, for example, like Chad Daybell, right? Okay. Idaho's death penalty scheme provides for 2 phases. One, where the culpability of the accused is determined, and then, if they are found guilty, a sentencing phase commonly called the penalty phase. And problematically, at the penalty phase, the jury must actually make 2 determinations. These 2 determinations are 1, whether the defendant is eligible for the death penalty, and 2, what is the appropriate punishment. Under Idaho code, blah, 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 a person is only eligible for the death penalty, and typo here, they left out the word if the jury, quote, finds beyond a reasonable doubt at least one statutory aggravating circumstance, end quote. If the jury determines that the defendant is eligible for the death penalty, then it must decide if it is the appropriate sentence. So first, are they eligible? Second, is it appropriate? Where a statutory aggravator is found, quote, the defendant shall be sentenced to death unless, and highlight this, unless mitigating circumstances which may be presented are found to be sufficiently compelling that the death penalty would be unjust. And we heard this exact language in Chad Daybell, right? When there's a statutory aggravator, let me say it again, when there's a statutory aggravator and they've gone through it, they found that they're eligible, they've seen that the jury's concluded that the aggravators are met, they shall be sentenced to death unless there's mitigating circumstances that are sufficiently compelling that they would find the death penalty unjust. And what's really interesting is because that's kind of a moral or ethical decision, right? Because what they're saying here is like, essentially the jury's following the law, and the law is like, here's what the aggravators are. And the jury finds, let's just say in the case that they find that those aggravators are met. That's the law is like, yeah, they're eligible for death, right? But then it's like this whole thing about, would it be unjust is what's so interesting. That's really more of like an ethical decision, right? Okay, in order to sentence a defendant to death, both findings, eligibility and appropriateness are required. The jury shall not direct imposition of a sentence of death unless it unanimously finds at least one statutory aggravating circumstance and unanimously determines that the penalty of death should be imposed. Combining these 2 distinct determinations into one sentencing proceeding violates a defendant's state and federal constitutional rights. This has become increasingly clear in recent years, given the Supreme Court's holdings in, and then it cites some case law here, which made clear that any factor that increases the permissible punishment must be found by the jury beyond a reasonable doubt. Okay, this is where it gets really interesting. Under Idaho's death penalty scheme, there are very specific statutory aggravating factors that make a defendant eligible for the death penalty. When determining eligibility, the jury must consider each statutory aggravator alleged and return a special verdict stating one, or I guess they're only listing one thing. So return a special verdict stating whether the statutory aggravating circumstances have been proven beyond a reasonable doubt. So what does that mean? It means it's the state's burden, right? Oh, keep reading, Chelsea. It is the state's burden to present evidence supporting each alleged aggravator. Okay. So let me just break this down. So essentially, right, we know we have the guilt phase, or as Ann Taylor calls it, the innocence phase, right? Which is in a bifurcated trial, which a death penalty trial is going to be bifurcated. In the states that have the death penalty, it's going to always be bifurcated, right? As in there's 2 different proceedings. So we know that we're all aware, hopefully, that, you know, when it's the guilt phase / innocence phase, that the burden, of course, is on the state, the prosecution, to prove beyond a reasonable doubt. But that what they're clarifying here is similarly, right? In this second phase, when it comes to the penalty phase, when it's a death penalty case, it is still the state's burden. They still have the burden of proof, right? They have the burden to present evidence supporting each aggravator, because the aggravators are key here. Okay, the Idaho Supreme Court has consistently held that the same facts cannot support more than one aggravator. This is important. Let me say this again, guys. The Idaho Supreme Court has consistently held that the same facts cannot support more than one aggravator because it presumes that the legislature did not intend to duplicate aggravating circumstances. Therefore, trial courts must instruct jurors that they are required to find independent evidence to support each statutory aggravator alleged. So this is huge. This is huge. This is huge. This is huge. And this makes sense. So let me just explain. So aggravating circumstances could be something like multiple victims, right? Like, for example, killing 4 people, right? Multiple victims, that could be an aggravator. Another aggravator, like take Murdoch, for example. He had an aggravator of what was like the use of a firearm, right? In other states, it might be like a deadly weapon. But there's, you know, there's a whole host of different aggravators. But essentially what it's saying is, if you take the same set of facts, let's say that for Kohberger's case, right? Let's just take the set of facts that would be the most obvious, right? Killing 4 people, allegedly. If you take killing 4 people, the fact that 4 people were killed, and you have an aggravator for the multiple victims, because it's 4 people, and then you have like, I don't know, let's say, you know, there's like, I think there's an aggravator of like especially particularly heinous and cruel, stuff like that. But it's still because he killed 4 people, something like that, where it's the same set of facts. What they're saying is you can't have the same set of facts cannot support more than one aggravator. This is huge because the state, I believe they have 4 or 5 aggravators that they're going for here with this death penalty. And if those, if any of those overlap on the same set of facts, they could get some of those dismissed, right? So this really matters because, again, the jury, if he's found guilty, they're going to have to weigh it out, and they're going to have to look at these aggravating factors. And remember, the first step, like we said, the first step is he eligible? And the way that that's determined is with these aggravating factors. So this is the first step in trying to save his life for his defense attorneys in the event that he's found guilty, because as we know, they have to be prepared for that way ahead of time, you know. And it was surprising to me too, because like in some places, in some states, you know, there's time between the guilt / innocence phase and the sentencing / mitigation phase, right? But like we saw with Chad Daybell, so maybe this is just the way it works in Idaho, you know, they just went straight into it same day. So either way, though, they have to be prepared. And so this is really smart. Okay. Even though the state must present very specific independent evidence supporting each aggravator, Idaho's death penalty scheme allows the state to present general non-statutory aggravation evidence. Non-statutory aggravation evidence is aggravation that does not support any statutory aggravator. This evidence can only be considered by jury when determining whether the death penalty is the appropriate punishment, not when determining whether a statutory aggravator exists. So in other words, this would be something that goes under the second tier, right? When it was like the 2-tier thing, which is like, first, are they eligible? And 2, is it the appropriate sentence? Quote, if the statutory aggravating circumstance has been proven beyond a reasonable doubt, right? That's step 1. Remember, that's step 1. Then the jury determines whether all mitigating circumstances when weighed against the aggravating circumstance are sufficiently compelling that the death penalty would be unjust. So the 2-step process, 1 step, 2 step, you know? So they're going to attack all this, which as they should. The trial in Hall exemplifies the difficulties created by this scheme. On the one hand, the legislature has indicated all relevant evidence may come in at the penalty phase. On the other hand, the legislature at the time had indicated that propensity to commit murder is to be shown by evidence of prior conduct or conduct in the commission of the crime at hand by permitting evidence relevant to aggravation, but not to a statutory aggravator. The legislature has created a scenario where a jury's decision is necessarily confused. So here's a law review article, and I think this is going to be one of their expert witnesses, Donald Hauser, that they're going to have, and boy, am I looking forward to this hearing. Really looking forward to this hearing. Because I think there's, I don't know. I think they've, anyway, I'll hold my thoughts. Okay, so he writes, the jury hears all of the evidence of intent factors, statutory aggravating factors, non-statutory aggravating factors, and mitigating factors in a single proceeding before making these 2 determinations. Receiving all of this information in a unitary proceeding creates a problem because the jury's determination of whether the defendant is eligible for the death penalty may be influenced by relevant evidence. That should say the, not they. The jury may find the defendant eligible for the death penalty based on evidence that, even if established beyond a reasonable doubt, fails to satisfy the statutory requirements of the death penalty, of death eligibility. The end result is that the issue of eligibility and punishment melt into a singular assessment. And there's the answer to that other question about, I was like, is it 4 or 5? In this case, the state has alleged 5 different statutory aggravators. So think of it this way. I think this is I think these are all really good points. Think of it this way. Imagine if, okay. Remember, guys, in any criminal trial, the jury never decides the sentence for a criminal defendant if they're found guilty, with the exception of the death penalty, which really it's kind of a recommendation to the judge, but they're usually going to go with what the jury says, right? So when you've got, like, this makes sense. Imagine, guys, if you will, imagine that you're a juror, right? And it's not a death penalty case. Let's just say it's a regular case where, let's say the possible sentencing outcomes, right? Because sometimes, judges have, mandatory minimum sentences, right? For example, like with Murdoch, for example, because of the fact that he had that aggravator with the weapon, there was no option I don't think there was any, it was going to be LWOP. There's no way around it, right? But it depends on the state. I can't even tell you how many times I've seen trials where it's like I can't remember which state specifically, but it's like, murders a bunch of people and it's like all these different things. And it's like, they're getting like 20 or 30 years or something. You know what I mean? Like, so it just depends on the state. So in some cases it could be, they get 10 years, 20 years, 30 years, all the way up through LWOP. And in other cases, it's kind of cut and dry. It's going to be LWOP, right? Or maybe LWOP versus life with possibility of parole. But imagine you're on a jury, right? And let's say you're in one of these states where there's a huge range of sentencing that could happen for this particular crime, whatever the crime is, okay? And let's say that you're on that jury and you're being asked to decide 2 things at once. One is, is the defendant guilty beyond a reasonable doubt, right? And simultaneously, you're having to decide what the sentencing should be. Imagine how that would be super convoluted and messed up, right? And to that end, that's why even when the jury is responsible for the sentence, which again only happens in death penalty cases, that's why it's bifurcated. So during the guilt phase, they're not even going there yet, right? Until after there's a verdict, and then they go into the penalty phase separately. So it makes sense to say that the problem they're saying in this filing is like they're being asked to decide 2 things at once when it comes to the sentencing phase for a death penalty case, because they're being, and again, I just use that example to say this is what it would be like because we don't have as many death penalty cases, right? But imagine again, if you're on a jury in a regular criminal trial and you're having to decide, if the defendant is guilty or innocent and the sentencing at the same time, that's like just, again, an analogy, another way to think of it. Similar idea where they're saying they have to decide if the state has proved beyond a reasonable doubt that the aggravating statutory aggravators have been met. And then 2, if, there's any mitigating factors that would render the death penalty to be unjust. And just they have to decide all that at the same time. I mean, that is messed up, right? I mean, I don't know. I think it's a good point. And this is where, right, again, this is what's this called again? This is a motion to trifurcate. You guys see? Because not bifurcate, but trifurcate. So before they're trying, there's going to be a motion to dismiss the death penalty or strike it, altogether coming up. But this is, this is like another option, right? Trifurcate. So that instead of having a bifurcated trial, it's trifurcated. I think this makes a lot of sense, but let's keep reading. All right. In this case, the state has alleged 5 different statutory aggravators. Mr. Kohberger anticipates that the state will attempt to introduce substantial evidence of aggravation, which is not related to any statutory aggravator, including evidence about Mr. Kohberger's past and evidence of Mr. Kohberger's character. The state will also seek to introduce non-statutory aggravation evidence in the form of victim impact evidence. This non-statutory aggravation should be presented during a separate sentencing proceeding after the jury has considered the issue of eligibility based on the statutory aggravators. Under this construction, there would be a culpability phase, which would be like the guilt phase, right? An eligibility phase, that would be were the aggravators met, and a sentencing phase rather than just 2 phases, culpability and penalty. Okay, guys, this makes so much sense to me. And let me just say this. I think about this all the time with every single trial when it's during the sentencing phase, when victim impact statements are given. And I don't think I've actually ever talked about this. I mean, it's not really come up, but this, I think about this all the time, and I'm so happy to see this in the document because this is addressing a concern that I've had for a long time. So, okay, again, sometimes judges they don't really have much wiggle room in terms of the sentencing guidelines, right? It just depends on the charges, depends on the state, depends on, if the defendant has had other charges in the past and, a variety of other things, right? So, but other times there is a range, right? And it's tough because it's like, are we as a society supposed to hope that a judge at sentencing for a trial, any trial, are we supposed to hope that the judge is going to be giving a sentence based on literally like the law and the charges and the evidence, right? Or are we supposed to really hope that they take into account the victim impact statements? How much the family's impacted, or if it's a victim that is a victim of a crime that they survive, right? Things like that. And is that supposed to affect sentence? Now, here's the thing. Well, they're going to actually talk more about it. I'm going to stop. I'm going to table that. I'm going to leave it to that question for now. The question. So let me just repeat my question. My question is, what should we hope for as a society? Should we hope that a judge is going to look at the evidence, the law, the criminal background and history, the charges, and sentencing guidelines, and impose a sentence based on that, or are we as a society supposed to hope that the judge is going to really listen to the victim impact statements and take those into account before making before issuing a sentence, right? Okay, that's the question. Okay, we'll come back to it. Let me read a little bit further here. The jury would only be presented with non-statutory evidence during the sentencing phase and would therefore only be able to use it in its determination of whether a sentence of death is appropriate. The consideration of non-statutory aggravation only for the purpose of determining whether the death penalty is an appropriate punishment is what is required by the statute. Trifurcating the proceedings is a way of ensuring that jurors are able to comply with the requirements of Idaho Code section blah, 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 and consider the appropriate aggravator at the correct time. Non-statutory aggravating evidence is any evidence that is not directly related to proving one of the alleged statutory aggravating circumstances beyond a reasonable doubt. There are many types of non-statutory aggravating evidence that the state may choose to present, including victim impact evidence. So again, why did I ask the question I just asked? Because victim impact evidence is non-statutory aggravating evidence. What does this mean? It means that it's going to be aggravating to hear it, essentially, right? It's going to be aggravating. It's going to make you want to punish the person of the crime. But it's not actually statutory, right? It's not included in any of the statutes in the Idaho Code or anywhere, right? For that matter. Which is what's so interesting about it, because it's really more of just like an emotional thing. Like it's not in the law, right? At sentencing, a quote, quick glimpse of the victim's life may be given in the form of testimony about the victim's life. Quote, however, this quick glimpse has morphed into a full-length feature film in some cases. The expansion of victim impact evidence in the form of expanded victim testimony and video presentations for the jury has furthered the need for trifurcation. When the jurors are emotionally overwhelmed by extensive victim impact evidence, they are likely to use the evidence and their grief for the victims to support, there's a typo there, to support statutory aggravators, even though it is unrelated. Okay. Hear me out on this. That's absolutely true. And again, that's why I gave the example of in a non-death penalty case where the judge is just making the sentencing, which is what we typically see because death penalty is rare. It's a similar thing, right? The judge is also exposed to this, right? That's why I posed that question. Are the judges supposed to be like, okay. Are the judges supposed to be, is that supposed to have an effect on their sentencing, right? Because if it's not, then shouldn't the victim impact statement happen after the sentencing is rendered? Like, for example, let's just say it's not a death penalty case, right? Let's say someone's found guilty, okay? Guilty of whatever the thing is. And then they come back and then the judge is giving them a sentence. Let's say it's 30 years or whatever the case is. Judge gives the sentencing, states all the reasons, gives all the law, goes through the, sentencing guidelines. And then the victims have a chance to do their impact statements. At that point, there's no problem for them to have any limitation on what they can say, right? Because the sentencing has already been decided. Like the verdict's been rendered, the sentence is there, it's a done deal. And so the thing is this, right? Because this whole thing, the expansion of the victim impact evidence, I feel like there's this thing of like, okay, it's really important, right, that the victims have a chance to express their grief and to be heard. And that's really, really, really important. Really important, right? But the trouble is I guess the question is really, what do we do about the overlap when that impacts the law? Because again, it's emotional testimony, but it's not statutory. Now, here's the thing. Here's why I said, hear me out, okay? Here's the thing that I think about all the time, watching trials. Especially whenever there's a lot of people getting up to speak about the horrible, horrible, horrible grief that they're suffering, right? And it's awful and it's emotional. And, one person after another, rightfully so, gets up and speaks about the impact it's had. And what we always see is we see this, like the example that I gave is not what we see. Like, in my opinion, it would make sense for this to occur after the sentence is given, but that's not what happens. The victim impact statements are given before the sentence. So again, it's like, that's why it's weird to me, because it's like, well, either the judge is supposed to take that into account, right? Or they're just supposed to ignore it and then issue the same sentencing they would anyway. But if that's the case, why would you not have the victim impact statements happen after the sentence is decided, right? So but time and time again, I feel like we hear in these cases when these victim impact statements are concluding that we hear the judge and they usually will say something, they will acknowledge it. And oftentimes it does sound like it impacts the sentencing, right? Now, maybe they're just saying that to try to, again, acknowledge and show that the victims are being heard. It's hard to really know how much, what really is going on inside their head in terms of how much of an effect that has. But here's my point, guys. Whenever I watch these trials where there's these, victim impact statements, especially when it's especially emotional and impactful and stuff like that, all I can think about is the victims of crimes who don't have families still alive, or they're estranged, or they're unidentified, and they don't have someone to speak up on their behalf. Let me give you an example. Cold cases, okay? I actually just saw something the other day about one that was just solved after like 70 years or something crazy like that. Somehow the dude that committed the crime was still alive, but the victim's family is long gone. There's nobody there. Another example, take Lisk, like the Long Island serial killer, you know, that situation. You know, some of those victims have families that have, but others are still unidentified, and some are identified but don't have family. So the thing that I think about all the time in these, whenever we hear these victim impact statements, is I think, what about these victims who don't have families that can speak up for them? Or maybe they have families, but the families don't feel comfortable. Maybe they feel like it's unsafe, or whatever the case may be. So in my mind, it's like, to me, it's like, well, that's unfair to them. It's unfair to the victims who are, you know, victims of horrible crimes, that just because they don't have people that are there lining up to speak on their behalf, it doesn't mean that the crime that was committed against them is any less cruel, right? So by that same logic, you can't say that it's any more cruel just because there's people that are there to speak up, right? So it's like, to me, it's like, you can't judge a crime by how many people are still alive that are related to the victim, or friends of the victim, or whatever, loved ones that are alive, willing, and able to come and speak. Like, that just, to me, is unfair, because that's like saying, that's like measuring people's lives and saying, I don't know, man, like, the taking of a human life, it's like the human lives are equal, right? So just because one person has 30 people still around that can come and speak at the sentencing and give victim impact statements doesn't mean that that person's life was more valuable, or that that crime was any worse than somebody who has only one person or two people or whatever, right? Because again, every human life is equally valuable. And so to me, and again, and the thing is like, for the victim, especially if the victim is deceased, or even if they're not, it's not up to them. They can't help it whether or not their family members are still alive. So it's like, you see what I mean? It's just totally unfair. And I think about this all the time, about the problem being, again, if the victim impact statements are allowed to make a sentencing worse for any criminal defendant, then automatically it's saying that for a criminal defendant who doesn't have victim impact statements being given at sentencing, that it's like that crime is less bad, right? It's just the way it is. So in my opinion, I think that the way to solve that issue, but also to eliminate this problem with, you know, the other issue being with victim impact statements, we've seen this in trials. And I can't think of any specific off the top of my head, but there's plenty of them where there's an issue about how long the victims are allowed to talk. Like, they have a time limit, or they can talk about this, but they can't talk about that, right? There's these limits. And why is that? Because it's before the sentence has been issued. But if the sentence has already been given, then the victims can be given, you know, free reign, essentially, I would imagine, right? There's not going to be any reason to give them a limit in terms of what they can say, what they can't say, how long they can talk within reason. You know what I mean? Because there's no rights involved once the sentence has already been issued. So in my mind, the thing that makes so much more sense to me is that whether it's death penalty or not, I think that, in my opinion, it makes so much more sense to say victim impact statements should be given after the sentencing has been given, and that way you allow them to speak from their heart, however long they want to do a video, whatever, and there's no issue with that. And then it doesn't feel icky, right? Because nobody wants people to have to go in there and tell the victims that they can't talk about this or that, or say, okay, sorry, your time's up. You know, that's icky too. But again, to me, the thing that just resonates with me the most is how unfair it is for people who just don't have family that can speak up on their behalf, because their life is just as valuable, right? All right, so back to the document. In addition to changes to the presentation victim impact evidence, changes in the law in recent years have made trifurcation necessary and rendered bifurcated death penalty schemes unconstitutional. Constitutionally, the bifurcated model became especially problematic after the Supreme Court's holding blah, blah, blah. In this case, the court held that statutory aggravators are elements of the offense of capital murder. Because statutory aggravators are elements of the crime of capital murder, they must be found by a jury. When statutory aggravators became elements, new constitutional problems arose. Factors once considered simply sentencing factors are now elements of the crime, and the bifurcated trial structure raises serious constitutional concerns. Evidence that a court would never admit at trial, such as victim impact statements, hearsay, and character evidence, is unquestionably permissible at the sentencing phase. However, during the jury's determination of a statutory aggravator, which is an element of the crime, the defendant is given none of the protections afforded the other elements of the crime adjudicated in the guilt phase. Yeah, I mean, true. The eligibility phase is akin to a guilt phase. Oh, this is kind of like the comparison I was making earlier. Is akin to a guilt phase, and that the state bears the burden of presenting evidence supporting each statutory aggravator it seeks to prove. Yep. Statutory aggravation evidence should be treated the same way as other enhancement evidence permitted under other Idaho statutes. For example, when the state seeks to enhance a sentencing by alleging that a firearm, again, like the example I gave with Murdoch, right? By alleging that a firearm was used in the commission of a crime, it presents evidence during the guilt phase in accordance with the rules of evidence. Yep. Similarly, when the state seeks to enhance a sentence by alleging that the defendant is a perpetual law violator, it must present evidence during the guilt phase in accordance with the rules of evidence. When a defendant is charged as a persistent violator pursuant to Idaho Code section blah, blah, the jury determines whether he is a persistent violator during a second proceeding. The persistent violator charge is stated in a two-part information. Initially, the jury is only informed of the offense with which the defendant is charged, part one of the information. And this is something that I don't know that I've really ever seen what they're talking about here, because usually we see that is not admissible, right? It's like other bad acts. But anyway, okay. When dealing with other enhancement statutes, judges have discretion to divide the proceedings into two phases. For example, Idaho law allows the judge to determine whether the firearm enhancement should be determined at one proceeding or two. Interesting. Huh. The court decides whether to give the firearm enhancement instruction along with instructions on the case in chief, or to allow the jury to deliberate on the case in chief first and the firearm enhancement second. Very interesting, depending on the case. Idaho law contemplates judicial discretion and separation of the determinations when necessary. In this case, with the voluminous amount of non-statutory aggravation that is expected to be presented, separating the two determinations into an eligibility and sentencing phase is necessary to ensure a legal and fair sentencing. Under the trifurcated model, only after the jury decides eligibility does it move on to the sentencing phase. In contrast to the eligibility phase, the sentencing phase, in which the jury decides whether the death penalty is appropriate, is more like a non-capital sentencing determination. At this phase, it is the defendant's burden to present mitigating evidence and the sentencer's role to decide the appropriate punishment. So in other words, again, they're doing a great job of making a distinction here where all the things that are typically happening in one phase in a death penalty case, as in the second part, but there's like multiple things going on, right? As we already said, they're making another distinction as to why it should be separate, because the whole part about the eligibility phase, part one, right? Remember, that's the state's burden. State has the burden to prove that they're eligible as per the statutory aggravating factors. But part two, right, is about the mitigation evidence, and that is where the burden shifts to the defense's, or the defendant's burden rather, to present the mitigating evidence and to prove that it's more enough to outweigh, or the way that Idaho words it, that it's the mitigating evidence would render the sentencing of a death penalty unjust, right? So that's so interesting, right? So you've got guilt phase, right? Burdens on the state, obviously. Then you have the death penalty eligibility phase, burden still on the state. And then you have this mitigation part where now the burden has shifted to the defendant, okay? So it does make sense. Again, another reason why it makes sense to separate it. Okay, unlike evidence of statutory aggravation, which must be proved beyond a reasonable doubt, mitigation does not need to meet this burden. Really, it's really more of like a, what's the right way to say it? Like an esoteric, or like, say it, like subjective thing, right? The jury does not need to find that the mitigation outweighs the aggravation beyond a reasonable doubt. The jury considers both statutory and non-statutory aggravation when making this determination. This is really more of like a just personal decision thing. It's really kind of interesting, right? It's like kind of abstract, I guess. All right, the Idaho Supreme Court has held that the rules of evidence do not apply at capital sentencing proceedings. The court has held that the admission of evidence in capital sentencing proceedings is governed by this Idaho code, which provides that the state and the defendant shall be entitled to present all relevant evidence in aggravation and mitigation. The Idaho Supreme Court has held that the right to confrontation does not apply to sentencing procedures. I'm not going to worry about reading that part. That just has to do with like cross-examining, basically. That's what that means. So, all right. Under a bifurcated system, the bulk of evidence in capital sentencing trials is admitted without rules of evidence. Much of the non-statutory, which is what, that's wild. Let me read that part again. My brain is like, what? Hold on, let me read that again. Oh my God. Under a bifurcated system, the bulk of evidence in capital sentencing trials is admitted without rules of evidence. My mind is like, why? What? How? That's insane, right? Much of the non-statutory aggravating evidence the jury is allowed to hear would not normally be admitted as evidence in the guilt phase of the trial. In a death penalty case, the rules of evidence in what should be the most carefully scrutinized area of law are entirely lax. I could not agree more. I could not agree more. As Sharon Turlington explains, this does not make sense. I agree. That's why I was just like, wait, hang on, what? That's why I read it again. I was like, my brain's blowing up because what? In the place where it should matter the most, right? That's insane. The rationale for this has been that while capital punishment demands increased reliability, the admission of more rather than less evidence during the penalty phase enhances reliability. If juries are not allowed to hear certain types of evidence because it is too prejudicial or not probative of an individual's guilt, why does that same evidence somehow transform into being more reliable simply because it is being introduced in the penalty phase? It seems that the opposite is true, that the sentence of death would be based more on past conduct than on the strength of facts in the current case. This should not be acceptable if our constitutional standards truly require that the death penalty be applied in a rational and non-arbitrary way. Yes. And isn't that the word I just used? Didn't I just use the word arbitrary? Or no, I said like esoteric and abstract, but I was trying to think of another word and that word was arbitrary. Like that's what I was grasping for in my brain just a second ago when I was reading like up here. Yeah, right? Wow. 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 The solution for allowing the maximum amount of evidence to be presented to the jury while not violating Mr. Kohberger's constitutional rights is to have a trifurcated proceeding. While the Constitution prohibits the introduction of character evidence during the adjudication of guilt or innocence, it also requires the capital trial to include as much individualized information as possible about the defendant. Trifurcation respects both of these constitutional requirements. Yep, I agree. It allows the maximum amount of evidence about the defendant to be presented while still complying with the state and federal constitutions. Yep. The third phase, and here's the thing. I don't know if this has ever been done. I've never heard of this, but again, death penalty cases are not that common. I've never heard of this trifurcation, but this makes so much sense. And honestly, learning what we're learning here, it seems like they should all be like this if it's a death penalty case. The third phase, the sentencing phase in which the jury determines whether death is the appropriate punishment, would be conducted like a regular sentencing proceeding. Yep, that makes sense. In which the rules of evidence are not applied and other rights, including the right to confrontation, are limited. All the evidence in aggravation that the state seeks to introduce is admitted in the final phase for the purpose of determining an appropriate sentence. I mean, even if they do trifurcate it, I'm going to stick to what I said, which is like, I still think that victim impact statements should be given after the sentence, but whatever. Okay. Several jurisdictions, and I wonder if they're going to address that as well. I mean, it might be that comes up whenever they have that hearing with the experts, but we'll see. All right. There's the answer to this question. Several jurisdictions have used the trifurcated system. All right, there you have it, guys. Wow. Learn something new every day. A trifurcated system would also protect Mr. Kohberger's right to confrontation. Unlike Idaho, a majority of courts who have addressed this issue, or the issue rather, have recognized that the confrontation clause applies to evidence used to establish an aggravating factor necessary to make the defendant eligible for the death penalty. The Fourth Circuit Court of Appeals has suggested that the right to confrontation applies during the guilt and eligibility phases of a trial. Interesting. That again is kind of in support that statement supports that there's like three phases essentially, right? Trifurcated. The court explained during the sentence selection phase of a capital trial, the jury exercises discretion in selecting a life sentence or the death penalty, and any facts that the jury might find during that phase do not alter the range of sentences it can impose on the defendant. Under the Federal Death Penalty Act, the jury finds the facts necessary to support the imposition of the death penalty in the guilt and eligibility phases of the trial. It is only during these phases that the jury makes constitutionally significant factual findings. Other federal districts courts have agreed. Blah, 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 blah. Okay, so that's great. They're saying people are agreeing. Good. Okay. Interesting. I think this trifurcation is a great idea, personally. So, but this is more just supporting it. Let's see what else we got going on here. Yep, so other places are doing it. Cool. Good. Excelente. Okay. Okay. Just looking through. In this case, given the extensive non-statutory aggravation that Mr. Kohberger anticipates the state will seek to introduce in this case, trifurcation of the proceedings is necessary to protect his state and federal constitutional rights. Failure to separate the penalty proceeding will lead to an arbitrary and capricious sentence in violation of the Eighth Amendment to the United States Constitution and Article 1, Section 6, blah, blah, blah. It will also violate Mr. Kohberger's constitutional rights under the 5th, 6th, and 14th Amendments to the United States and other things as well there, due process. Additionally, it would violate his right to confront witnesses, blah, blah, blah. Conclusion. Trifurcation of the proceedings is necessary to protect Mr. Kohberger's state and federal constitutional rights. Mr. Kohberger respectfully requests that this court grant the motion to trifurcate the proceedings into a guilt, eligibility, and sentencing phase. Mr. Kohberger also asks that this court apply the rules of evidence to the guilt and eligibility phases. Yeah, 100%. Do it. Like, this is a no-brainer to me. I think everywhere should be doing this. Okay, let's see what the next one is. So one down, a million to go. Just kidding, but also not really kidding. All right, so let's see what we got here. Look at that, is a long caption, isn't it? All right, motion for the court order requiring the state, 1, to provide notice of every alleged non-statutory aggravating fact or circumstance that may rely on its sentencing of the trial, and 2, to prove beyond a reasonable doubt every alleged non-statutory. Whoa, back up. Hold the phone. Okay, I'm glad we did the documents in the order we did, because we just covered, guys, what does it mean when they say non-statutory aggravating things? They're talking about victim impact statements. That's what they're talking about, right? That's the only thing it is, right? Everything else is going to be statutory. The non-statutory, we're talking about, again, victim impact statements, emotional evidence, testimony, that type of thing, right? This is so at first it's like, okay, provide notice of every alleged fault. So in other words, that'd be like providing notice of who's going to testify for victim impact statements. You know, this is kind of in the future, right? But like they have to prepare for it. But this is why I was like freaking out. 2, to prove beyond a reasonable doubt every alleged what? Are you guys seeing that? What? Oh, I can't wait to see what they're going to, like, how would you have them prove it? Okay, let's see what this says. This is insane. Wow. Okay. Let's see what they say. So here's the first one, right? Because again, they had 2 things. Here's one. Notice of non-statutory aggravating facts and circumstances. In State v. Hall, the Idaho Supreme Court held for the first time, that evidence of non-statutory aggravating circumstances is admissible in the capital sentencing process, and that it may be considered by the jury to determine whether to sentence. Oh my God. So there you have it. So let me just reiterate. In 2018, the Idaho Supreme Court for the first time held that victim impact statements essentially can be considered by the jury in determining whether to sentence someone to death or life. I don't care for that at all. Because again, I talked about that, you know. I could go on with an infinite list of reasons why that bothers me, but to limit it to what I've already discussed, it's unfair for people who, okay. In a situation where it seems like the death penalty is a good idea and that should be happening or whatever in places that are in support of that, and for people that are in support of that, and it would be unfair to victims who don't have people to speak up on their behalf, to be unfair to those victims, right? Anyway, okay, I already mentioned all that. So, wow. Mr. Kohberger has argued elsewhere that Idaho's capital sentencing scheme, as articulated in Hall, is unconstitutional due to its arbitrary nature. Mr. Kohberger maintains those arguments here. However, if the court disagrees and holds that non-statutory aggravating circumstance evidence will be admissible at any potential sentencing phase, then the court must enter an order requiring the prosecution to provide him with sufficient notice of any non-statutory aggravating factor circumstance it intends to introduce, blah, blah. Such notice is required by due process, da, 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 da. Okay, let's see. Where do they get to the second thing? Because that's going to be insane. Cat, hiya. Glad you're here. I don't know why you're you don't have to apologize. I remember that was happening right before my internet went out. So we didn't even get to finish that conversation. You're okay. You don't have to apologize. It's all good, man. I know Spencer was explaining some fancy term about it, and I was like really excited to learn more about it, and then I lost my internet connection. Okay, so glad you're here though. So let's see here. I want to get to Roman numeral 2. Because that's going to be interesting. How are they supposed to prove these things beyond a reasonable doubt, like in a factual way? Okay, let me find that. Okay, burden of proof. Y'all, what are they going to say? This is wild. In addition to requiring the prosecution to provide sufficient pretrial notice of non-statutory aggravating facts and circumstances, this court must require the state to prove beyond a reasonable doubt any non-statutory fact or circumstance it is permitted to introduce against Mr. Kohberger. Failure to do so would violate the due process and the cruel and unusual punishment clauses of the United States and Colorado constitutions. Statutory aggravating factors are required to be proven beyond a reasonable doubt to the unanimous satisfaction of the jurors. So again, the statutory aggravating factors, that's a no-brainer. That's things like, again, to give the murder example, having a firearm, right? Or it could be killing more than one person, whatever the case is. That's the law, right? Jury's gonna have instructions on that. All right, so that's not the gray area. The state must be held to a similar burden with respect to the quote other aggravating evidence, end quote, that was created by and embraced in Hall. The statute does not mention the non-statutory aggravating circumstances or other aggravating evidence, but in the light of the power granted them by Hall and in the light of precedent, and the beyond a reasonable doubt standard should apply to them as well. Oof, I think they're gonna have trouble with this one, but we'll see. What are they gonna do? All right, they're saying here in People v. Tennyson, the Colorado Supreme Court held that the burden is beyond a reasonable doubt. But that's not binding authority to you, though, but okay. An instruction to the jury that they must be convinced beyond a reasonable doubt that any mitigating factors do not outweigh the proven statutory aggravating factors before a sentence of death can be imposed adequately and appropriately communicates the degree of reliable. I mean, I'm not even going to bother reading this because honestly, it's like, this is not. This has no impact on Idaho, right? What they do in Colorado does not impact what they do in Idaho. It's not binding authority. Okay, so can we get something from Idaho, man? Let's see. Yeah, they're gonna have trouble. They're gonna have trouble, I think, with this one. Yikes. Yeah, that's not. So this is what they're doing. The reason there's all these documents, in my opinion, is they're going through all of the different ways to try to get this death penalty either A, thrown out, reduced, trifurcate, like all of the things. So this is just one of the things to say that they would have to prove anything that comes in from a victim when a victim impact statement. But it's just, I don't even know how you would even do that. But they're saying if they can't do it, it's a violation of constitutional rights. But they've only got Colorado case law to back that up. So I don't think that's going to go anywhere. Nah, it's not going to go anywhere. I would say. I would bet my bottom dollar on that. All right, next one. Woo! Moving right along. Okay. What do we have next? Motion to strike felony murder. So here we go. Remember, guys, like they said, there's 5 aggravators. What they're going to do is they've got to try to strike all of these, right? One by one. The more they can strike, the better, right? Because again, this is the first step in for the jury. If he's found guilty and it goes on to this death penalty phase, right? Their first step is he eligible? And remember, how do they look at that? They're going to be given the law, and it's going to be looking at these aggravators, these statutory aggravators. So the less of those he has, the better, right? Okay, for if you're his defense attorneys, in other words. So, all right, let's take a look. Motion to strike felony murder aggravator. All right, issues. 1, whether felony murder can be predicated on burglary itself, predicated on murder. So my guess is this is the one where it says, because I remember when he was being charged and all this was happening, it was the thing of like, if you enter a home, that's by definition, like that's considered burglary. Like you don't have to steal anything, right? Growing up, it's like, I always thought burglary is like you picture a guy with like a black trash bag and he's stealing some jewels, you know what I mean? But burglaring is like entering the house essentially, right? Like it's not, you don't have to take anything, in other words. So, but it's like this felony, this aggravator is like if you burgle, as it were, while also murdering. Okay. So number 2, whether malice aforethought murder can be aggravated by a burglary. So it's like, look at this. It's like circular thing. Let me read that again. This is wild. So number 1, whether felony murder can be predicated on a burglary itself predicated on murder. 2, whether malice aforethought murder can be aggravated by a burglary predicated on the same murder. Oof, that's something, right? Wow. Like a cat chasing its tail. Felony murder cannot be predicated on a burglary predicated on murder. I mean, that sentence makes sense to me because this seems insane for anyone to say that this would be true. Yeah, circular reasoning, right? It is impossible to charge felony murder on the basis of a burglary with the intent to commit the murder in question. I would agree. The state has given notice that it intends to show the murders in this case are aggravated because, quote, the murder was committed in the perpetration or attempted perpetration of a burglary. And the defendant intended a killing, or acted with reckless. So my guess was right when I was trying to guess what this was going to be about. Yeah. Or acted with reckless indifference to human life. In count 1, the state charges that Mr. Kohberger committed burglary by entering a residence. Right? There's the burgle. There's the burgle for you guys. He entered the residence with the intent to commit the felony crime of murder. Again, it's like, whoa, burgling is not what I thought it was. Counts 2 through 5 are all counts 2 through 5 all charge premeditated murder. In other words, the state seeks to prove the aggravated circumstance of this murder by showing intent to commit murder at the time of entry. I mean, yeah, it's a bit wild. Yeah, I agree. Now we're gonna cite the Supreme Court of California. Why? I have no idea. They should be citing Idaho or federal. Like, let's get some U.S. Supreme Court up in here. All right, states have taken different approaches to whether it is possible to charge felony murder, where the felony is a burglary with the intent upon entry to commit murder. Okay, I'm just going to scroll down here. Okay, let's just see what else. The concept of committing a murder in furtherance of a burglary committed with the intent to commit that same murder has been rejected by multiple jurisdictions. Yeah, I'm not surprised. Okay, 2, malice aforethought murder cannot be aggravated by a burglary predicated on the same murder. Yeah. Let's see. A bunch of stuff. Finally, California again. I mean, it'd be nice if they had some Idaho case law, but all right, let's just get to the conclusion. Conclusion, based on the foregoing and argument to be presented at the hearing hereon. Oh, I'm excited for this hearing. I can't wait for this hearing. This court is respectfully requested to grant this motion that felony murder aggravator in the state's notice be struck and the court not. I don't want to know, when is this hearing? I don't know that they've scheduled it yet, but man, I can't wait for this hearing. Oh my God. Okay. Counsel estimates 20 minutes for the hearing. Okay. So yeah, so there's no date set, but that means this one issue, right? So there's this whole slew. My guess is going to be at least a full day for this, for them to address all this. I mean, at least this is going to be a lot. Okay. Yay. Another one down. Next up. Ooh, sorry. What have we got here? Okay. Motion to strike HAC Aggravator. Let's find out what that means. This is the one I referenced earlier too. Remember when I was like, I gave an example and I said heinous, atrocious, and cruel? Here we go. He has that one as well. So this is aggravator of the 5, right? Because we know he has 5. This is the second one, I believe, right? Yeah, HAC. Okay, so the first one was the Burgles. Okay, this is the HAC. Official terms. Heinous, atrocious, or cruel. All right. Manifesting exceptional depravity. This motion is made on the grounds that this aggravator is unconstitutionally vague and fails to narrow the class. I mean, I agree. And this is the whole thing, right? Because that's one of those things where it's all relative, right? I mean, heinous, atrocious, and cruel. It just, dude, you know? Anyway, okay, let's keep going. Let's keep reading before I go off on a full tangent about that. 8th Amendment. The United States Supreme Court has stated that the 8th Amendment's prohibition against cruel and unusual punishment made applicable to the states through the 14th Amendment prohibits a state from imposing the death penalty in an arbitrary and capricious manner. Well, then I don't know what we're even doing with any of this because, yeah, wow, I didn't even know that was a thing. I did not even know that was a thing. Instead, the sentencing body must be provided with standards which will genuinely narrow the class of crimes and the persons against whom the death penalty is imposed. I mean, you know what, though? Like, having said that, this makes sense as to why it's, like, not really done that often anymore, right? Like, most states aren't even doing it. You know, they've either, like, outlawed it or, you know, it's still allowed but doesn't ever happen, which is, like, the case in North Carolina from what I understand. I don't even know the last time that we have, by we, I mean the state has sentenced someone to death, but I think it's been a long time. I'll look that up though. But yeah, you know, there's few states that are actively doing that from what I think there's like 8 of them or maybe fewer. Let's just, since I'm talking about it, let me look it up. Let's just do that now. Otherwise it's going to bug my squirrel brain. So the death penalty is hold on. Oh, here's a good article thing, I think. Okay, here are the US states that are currently applying the death penalty, right? So using it, right? Alabama, Arkansas, Florida, Georgia, Idaho, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Nebraska, Nevada. Is that all of them? Oh, wait, no, that's not all of them. Kentucky, Louisiana, Mississippi, Missouri, Montana. Wait, I already read that row. Why is it? Oh my God. North Carolina, Oklahoma, South Carolina, South Dakota, Texas, Utah, Wyoming. Okay, there are another 6 states where the death penalty is legal, but no executions are taking place because the governor has prohibited them by executive order, or they've been halted. So those states are Arizona, California, Ohio, Oregon, Pennsylvania, Tennessee. Interesting that Tennessee's on that list. And Arizona, I thought Arizona did still have the death penalty. That's interesting. Oh, it says in some of these states it's logistical problems, like they didn't have enough of the stuff to execute people or whatever. States without the death penalty: Alaska, Colorado, Connecticut, Delaware, Hawaii, Illinois, Iowa, Maine, Maryland, Massachusetts, Michigan, Minnesota, New Hampshire, New Jersey, New Mexico, New York, North Dakota, Rhode Island, Vermont, Virginia, Washington, West Virginia, and Wisconsin. In 2023, executions occurred in just 5 states: Alabama, Florida, Texas, Missouri, and Oklahoma. It says the executions have become less and less common. Yeah. On July 1st, 2021, the U.S. Attorney General also paused federal executions while investigations continued into the practice. Yeah. I wonder when, well, I don't want to, I was going to say when the last in North Carolina actually used it, but anyway, so there you go. That's some information there. All right, back to the document. So, to pass constitutional muster, a capital sentencing scheme must genuinely narrow the class of persons eligible for the death penalty and must reliably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder. The court stated, the narrowing function required for a regime of capital punishment may be provided in either of these 2 ways. The legislature may itself narrow the definition of capital offenses, as Texas and Louisiana have done, so that the jury finding of guilt responds to this concern, or the legislature may more broadly define capital offenses and provide for narrowing by jury findings of aggravating circumstances at the penalty phase. That makes me so uncomfortable. The clear provisions of the Idaho statute provide that the narrowing occur in the sentencing phase of the trial. Yeah, that's messed up in my opinion, particularly here where the allegation is simply premeditated murder. So in other words, if you're in Idaho and you're like getting their like death penalty on the table, like this is like the worst. These are all the worst circumstances. Like so far from everything we've seen, it's like where there's these different options. Like Idaho, it's like all of them are the worst. Like what? So, Yeah, so but it says that they've paused it though. It said the US, which I didn't know until I just read this. This is on a 2024 law thing. That said on July 1st, 2021, the US Attorney General also paused federal executions while investigating. So they're paused. So he could, so in other words, people can still be sentenced, but in terms of the actual executions taking place, they're paused. So yeah. Okay, so the only thing that does suck though is we're not going to be able to watch that trial, right, for Farwell because of the fact that it's federal. Sucks. Actually, no, hold on. Now I'm trying to remember. Are they also charging him? Is the state also charging him? Why do I feel like I heard that or read that somewhere? That he's being charged both from the state and the feds, like Murdoch style. I don't know for sure, but okay. So, because if that's the case, then we'll get to see the state try, unless he pleads. But anyway, so so this is wild. So let me just reiterate this. So they're saying that in terms of narrowing down who can be eligible, right, for the death penalty, there's 2 ways to do it. You can either have the legislature do it by narrowing the definition for capital offenses. Let me give you an example. So we already just read the list and I already knew this, but that New York does not have the death penalty, right? Just to use it as an example, though, even though it's not death penalty related, first-degree murder in New York is not like it is other places. For first-degree murder in New York, you have to have actually killed something like 3 people, I think, and it has to be like within a certain period of time. So essentially, in order to be charged with first-degree murder, you basically have to meet the criteria to be considered a serial killer, which is wild, right? But that's a legislature. The legislature narrowed, right, the number of people who could be eligible for first-degree murder by adding that huge caveat that really narrows it down, right? So just as an example, so they're saying the legislature can do it by narrowing the definition of capital offenses, which is what Texas and Louisiana have done. So the jury finding of guilt responds to this concern. Or the legislature can more broadly define capital offenses and then kind of leave it up to the jury during the sentencing or the penalty phase. That's messed up in my opinion, but that's what Idaho has. So that sucks. That said, aggravating circumstances must meet two requirements. Circumstance may not apply to every defendant convicted of murder. It must apply only to a subclass of defendants convicted of murder. And the circumstance must not be unconstitutionally vague. Okay, let's go on. Legislature. You guys, how much you want to bet Jay Logston wrote this? Oh my God, legislative history. Okay, well, I have to read this because I think this is amazing. And I freaking loved that document that went all the way back to like since the dawn of time. It was like my favorite thing. How much you want to bet Jay Logston wrote this? Hold on, let me just see. This is page 3. We'll come right back to it. Let me just see. Was it him? Was it him? It is history time, guys. Oh my God. This one's not as long as the other one though, unfortunately, because I thought that was again amazing. Huge fan. I'm gonna need to get some more water though if we're going into this judicial gloss. Okay, hold on. Be right back. Let me get some more water. And in case anyone's wondering why we're doing the documents now, because everything that was coming up in this PowerPoint presentation was just making me think about all the issues at hand that are discussed in these documents. So I just couldn't help it. I was like, this is relevant. Let's do it. Cat thing state. So they haven't charged yet. Okay. I wonder if they will. I hope they do, because that way there can be a trial. Although having said that, Massachusetts, I mean, is there even a point though? I guess not. Can another state charge him so we can have a public trial somewhere else and we can see it? Okay. All right. Legislative history. Legislative history. Get your snacks, guys. Get your water. Get your coffee. Whatever the case is. Idaho's legislature has made it an aggravating circumstance where, quote, the murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity, end quote. This aggravator first appeared in the Model Penal Code in 1962. I certainly hope we go back further than that in history. The state of Idaho shares this exact statutory language with one other state, California. The Supreme Court of California has ruled that this language is unconstitutionally vague. Okay, fair point. Judicial gloss. Don't even know what that means. Idaho's highest court has placed a judicial gloss on this statute such that the state must show. Quote, we feel that the meaning of such terms is a matter of common knowledge so that an ordinary man would not have to guess at what was intended. Objection speculation? I mean, what? I mean, one man's heinous, atrocious, or cruel is another man's who knows what. I'm not even going to go there. Speaking of Farwell, right? It is our interpretation that heinous means extremely wicked or shockingly evil. And the thing is that this has an inherently religious connotation to it too, which shouldn't be happening because obviously separation of church and state. So that's another reason I hate this. Evil also is leave that for Disney movies, in my opinion. That atrocious means outrageously wicked and vile. I hate this shit, man. And that cruel means designed to inflict a high degree of pain with utter indifference to or in suffering. Now, this is the one thing I think is actually like fair here in terms of fair to use when it comes to the law. Like the word cruel, you can define it, and this is not imaginary. It's not like this is more objective, right? Cruel. What is cruel? It means inflicting pain with a utter indifference to or enjoyment of the suffering of others. Yeah, that I think makes sense. What is intended to be included are those capital crimes where the actual commission of the capital felony was accompanied by such additional acts as to set the crime apart from the norm of capital felonies, the conscienceless or pitiless crime, which is unnecessarily torturous to the victim. In interpreting this portion of the statute, the keyword is exceptional. It might be argued that every murder involves depravity. Yeah, right. I mean, this is where it's subjective, right? Everything's relative, man. The use of the word exceptional, however, confines it to only those situations where depravity is apparent to such an extent to but what does this even mean, though? This is, oh my God. I mean, right. I'm remembering their point is that it's vague, and I would agree 100%. With these constructions, i.e. that the murder must be accompanied by acts setting it apart from the norm of murders, and that its commission manifests such depravity as to offend all standards of morality and intelligence. Again, one man's being offended by is another man's cup of tea, right? The aggravating circumstance contained in blah blah is sufficiently definite and limited to guide the sentencing court's discretion in imposing the death penalty. Despite this ruling, the Idaho, what is this then? The Idaho Code, maybe for something rather, or the HAC heinous atrocious or cruel states. The term especially heinous atrocious or cruel are considered separately, but in combination with manifesting exceptional depravity, the terms heinous, atrocious, or cruel are intended to refer to those first-degree murders where the actual commission of the first-degree murder was accompanied by such additional acts as to. This is insanity. This is again so much circular, just like with the burglaring, with in the commission of oh my god, man, wild. A murder is especially heinous if it is extremely wicked or shockingly evil. Guys, atrocious means outrageously wicked and vile. Okay, hold on. There's only one thing to do here. There's times where there's only one option, and that is to goat. Because I cannot not goat. I have to. This is just absurd. You know what? The premise that people's lives should be decided on this type of shit, to me, that is extremely wicked, shockingly evil, atrocious, wicked, and vile to me. Okay, and cruel. Let's just throw that into the mix. That's the only. I would say it's impossible to define anything with those vague terms that are completely speculative and subjective, with the exception of this being something that is in the legislature to determine someone's life or death. You guys, I'm gonna break my goat, man. Okay, one more goat. Okay. Ugh. I'll be honest, like I have to not think too hard about this or I'll get really upset. So, because I just, nope. Yeah. So, all right. Let's keep going. The statutory aggravating factor does not exist unless the murder was especially heinous, didn't we already read these things a billion times? No, I'm not, this is not Jay Logsdon. This is right. This is from the Idaho, code, it seems like, where they're describing this. And this is just, it's just literally repeating the same thing over and over again. What? It might be thought that every murder involves depravity. However, exceptional depravity exists only where depravity is apparent to such an extent as to obviously offend all standards of morality and intelligence. I'm sorry, but that varies. Dude, I cannot. What is with this whole thing of assuming that everybody thinks the same? It's disgusting, in my opinion. Like, ugh. The terms, especially heinous, manifesting exceptional depravity, especially atrocious, manifest. Oh my God, why is it just the same thing over and over again? Blah, blah, same thing over and over again. It focused on the defendant's state of mind at the time of defense, as reflected by his words and acts. Okay, courts in Alabama. They've narrowed it down to psychological torture. Arkansas. Something similar there with California. In Florida. This is so vague, though. In Florida, they say, well, this is from 1973, we have also stated that unlike the cold, calculated, and premeditated aggravator, which pertains specifically to the state of mind, intent, and motivation of the defendant, the HAC aggravator focuses on the means and manner in which the death is inflicted and the immediate circumstances surrounding the death. I mean, what the fuck, man? In Georgia, it is an aggravator if the murder was outrageously or wantonly vile. horrible. Dude, one time when I was a little kid, I was like in first grade. I never like ate breakfast really, but like growing up, but like for this one day, I decided to have cereal for some reason, and I think it was Honey Bunches of Oats. And my parents, well, I guess my mom like had bought. I thought it was milk because it was in a container that looked like milk, okay, but it was orange juice. But it looked like milk. It was in a funny container, and I accidentally poured orange juice on the cereal. And while that might sound like it would be delicious in theory, I will tell you, it was horrible, and I couldn't eat it. So again, I mean, that's an example of horrible. I mean, All right. This is a jury instruction for some other state, so I'm not going to read it because it's not the state that this trial is in. Indiana. Okay, well, this is not the history I was looking for. This is more like current. I wanted history. Oh, okay, hold on. In North Carolina. All right, let's read this part. How mad am I going to get at the state that I'm living in? All right, let's just see. In North Carolina, the aggravator reads, the capital felony was especially heinous, atrocious, or cruel. The Supreme Court of North Carolina has adopted the following jury instruction to provide more guidance to the jury. Under the evidence in this case, one possible aggravating circumstance may be considered. Was this murder especially heinous, atrocious, or cruel? In this context, heinous means extremely wicked or shockingly evil. Yep. All right, I'm moving. Ugh. God, I'm not even going to read anymore. It's all the same stupid bullshit. So, all right. This is more just going by each state and how they define it. And I don't know that any of them are doing better than the other. I think it's all stupid. All right. Argument. The court should strike the HAC aggravator in this matter. First, this court should find that the gloss placed on the aggravator by the Idaho Supreme Court was in violation of the Idaho Constitution. Without this gloss, the wording of the aggravator has already been struck down by the Supreme Court, or California Supreme Court, rather, the Eighth Circuit, and in alternate forms by the United States Supreme Court. Additionally, the saving construction does not actually appear in the ICJI for the aggravator. Separation of powers. Oh, interesting. Using the dictionary. The instruction to show they're using the New Oxford American Dictionary to define heinous. Interesting. Heinous means utterly odious or wicked. That atrocious means horrifyingly wicked, and that cruel means willfully causing pain or suffering to others or feeling no concern about it. Conclusion. Based upon the foregoing and argument to be presented at the hearing hereon, this court is respectively requesting to grant this motion that the HAC aggravator be struck and blah, 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 blah. Okay, what's next? So again, that was the second aggravator, and there should be 5. What's the next one? Multiple victims aggravator. All right, we're going to take a break from the documents, and we're going to head back to the hearing. Little change of pace. I could see that being great. I could see that being great. I don't know. It was Honey Bunches of Oats, and it was literally the worst thing I've ever tasted in my entire life. And in fact, I think I had my brother try it to see if he could eat it, and he couldn't. He like spat it out, and like same with my dad. And then like no one could eat it basically. So like it was that bad. And I will say that in my family, Honey Bunches of Oats was the favorite cereal of choice by everybody. And so it wasn't the cereal, but I could see fruity problems with OJ. I could see that being a thing. All right. So now let me pull back up. Hold on. I have to switch this to do the things, to switch the things over. Okay. Pull back up the hearing. Okie dokie. All right, back to the hearing. So again, we're still in Dr. Edelman's PowerPoint presentation here. Good little break from the documents while we process all of that. Okay, cool.
Sounds like a tough road that can be created by a lot of media exposure.
Can be.
Can you tell us about any studies you know about how evidence might be evaluated?
Yeah, so this is just an example again. So in this particular piece, the researchers were looking at something called pre-decisional distortion. It's kind of like disconfirmation bias. So people were exposed to negative pretrial publicity or positive pretrial publicity about the defendant. And then there was delay. So I think it was like 5 days or something like that. And they watched a murder trial where a husband was accused of murdering his wife. And it was intentionally balanced. So it was kind of like a 50-50 split of guilty, not guilty. And what they found was that at each point in time, they would stop and do a case evaluation and assessment. And people hold the evidence to be consistent or supportive of whichever leader they had. So if they had started the case where they were supporting, they had been exposed to negative pretrial publicity, they would be supporting conviction, let's say the prosecution. So they didn't look at that evidence just for the probative value, but it anchored closer to its supports conviction. It's consistent with the belief I already have. And it was consistent like that throughout the entire study versus those who maybe had seen neutral pretrial publicity. You didn't see that. So people were more likely.
Uh-oh.
How about when you've had a lot of pretrial coverage and then you have a lengthy trial? What do you know about a risk of confusing where you heard the information? Yeah, that I mean bringing in something that you heard a long time ago that didn't happen.
Right. And think about it based on what you're saying. These studies we're talking about an effect that was discovered with maybe 1 or 2 articles, and it still had an impact. Case like this, you're talking about inundated with pretrial publicity over a significant amount of time, repeating information, and then new information that's sensational. And so it's constantly reactivating those memories and making those knowledge structures more accessible, both consciously and unconsciously. So those attitudes are even stronger. So you would expect to see an effect like this to be even more robust in a trial setting over the course of weeks, months, or whatever it is.
All right, let's talk about surveys and what you do.
Sure.
Tell me what you do when you want to do a survey.
What do I do?
Yeah.
Well, so there's 2 different phases. So I don't start with I'm going to do a survey. So when I'm first asked to look at this, the first thing I do is collect the newspaper coverage. And I try to take a conservative approach. So I take the papers that have significant circulation in the county, that are based in the county. So I'm not looking, for example, at a paper in Spokane or in Ada County. I'm just looking at the ones here. And I read that coverage and I make an assessment if there's extensive coverage and potentially prejudicial coverage. So what is the nature of the coverage? Does it include inadmissible content? Does it include a lot of detail about test results like DNA results and things like that? So conviction-prone evidence. Is it have presumption of guilt or guilt-oriented detail? For example, public officials making statements about a defendant's guilt, victim families talking about that, things like that. Emotional pretrial publicity, because we know from the research the most prejudicial types of media coverage is emotional pretrial publicity, inadmissible content, and information about the defendant's character. So those are 3 big ones. So really looking at that. In every case is different. So in some cases, it's all about the community impact, and there's candlelight vigils and memorials, and it just shocked the community. In bigger places, you don't see that as much, so it might be something very different. So it's always dependent on the case. If there is not a lot of coverage or it's very neutral and basic, I wouldn't recommend doing anything else. So it would just stop there. If it's extensive coverage or sensational coverage or something like that, we would move to this next step, which is doing a phone survey in the venue. Sometimes we do a comparison survey, sometimes we don't. Yeah.
All right. I think you told me a little bit about the analysis of the coverage, but will you again tell me what you're looking for specific to a county before you decide to do a survey?
Actually, the main thing I'm looking for
when you're deciding whether or not to do a survey.
It really depends on the case, right? So every case is different. There's no like, I'm looking for X and is there or not. Every case is unique. Every case has, like, sometimes an example would be maybe this case went to trial 5 years ago and there was a conviction and then the conviction was thrown out. So really the unique thing there is exposure or knowledge that this person's been convicted is highly prejudicial. Sometimes there's a confession and we know from the research in the Supreme Court that confessions are considered one of the most prejudicial things that could be out there in terms of media coverage, that when we talk about change of venue. So maybe that's a factor. It always just depends on the case.
And do you look at the coverage to the local area you're talking about?
Yes.
What did you find for Latah County as far as coverage?
So just looking at the Moscow Pullman Daily News and the Idaho Argument, I found 240 articles going from 2022 to 2024, stopping in June. So I don't know what's been published since in terms of collecting the coverage. So that's the extent of the coverage in those 2 papers. I believe I also provided the Lewiston Daily, I think it is, or the Tribune, is that right? As well, because in the survey, a lot of people mentioned they read that paper. So I put that in there as well and turned that over. And I think that was like another 200 articles or something like that.
Do you know the total number of newspaper articles you collected from those 3 papers between the dates of November 13th, 2022 and June?
Yeah, so approximately 441.
Now you've provided this chart and you have Mr. Kohberger's name highlighted at the bottom of this.
Yeah.
What's significant about this chart that you've presented?
So one of the tricky things is always what is a lot of coverage. So there's no decision that I'm aware of where it says if you have X number of articles, that's considered sufficient for a change of venue. So what I did was I pulled cases where the population or the county where the case was initially venue were between 27,500 and 62,000. And I did that because we fall somewhere in there. We're at like 32,500, I believe, 18 or over here. So just trying to look for a range of cases to get a decent sample size and look to see how many articles were published in those cases and what the median was. So it's not impacted by extremes. And what I found was these 16 cases that fall within that range. And the median number of articles in those 16 cases was 85. And in those 16, there were 12 change of venues granted in that case. And if you look at those which had more than 80 articles, should be 85 median, it's 78%. And Kohberger would fall at the bottom right now because he's at 444. And I think, is it Daybell would have been, I think there was approximately 200 and change in that one. And that one was recently moved to 8 account.
And these are articles from the 3 newspapers only, not talking about any other source of media.
Just the 3 papers.
Okay. Let's talk about how much media coverage there is. It's not just these 3 newspapers, is that right?
Right. So I did an analysis of the coverage that's in the declaration, which is more of a qualitative analysis. So I'm not going to go through that because that would be pretty laborious. So what I have here is looking at kind of consistent, some of the television coverage and some of the information that's been spread through more informal channels, such as social media.
What did you find?
Yes. So again, like this is really looking at what people are seeing on social media and through informal communication networks. And the reason I did that is because it's a small county, and in small counties, people talk. So people are more likely to know, rumors and speculation because people know the victims, they know the defendant, or someone's worked with somebody who knows the defendant or victim. So from my experience, you have a lot of information disseminated through informal communication channels and through social media in high profile cases.
Did you find that in this case?
I did. There was quite a bit.
What are we seeing on this slide?
So this is just an example. I went on Facebook and just did one search, which was just the search term was Moscow murders to see what would come up. And this is what we would call a results page, essentially. So if you hit play, you can see the extent of content that's out there from groups that are just talking about this case and sharing information and discussing what they think happened, and videos and posts, which may include anything from influencers and podcasters to sharing traditional news stories through local newspapers or television stories. But there's quite a bit. And again, this is just one search.
It looks like you did a screen capture so that you could show the results from one search term.
Yes, this is me just scrolling through the search engine results page from that one search term. And what you're seeing is a combination of everything. And then if you click on the tabs like posts or groups, you would see other categories. What's remarkable is the number of groups that have been created discussing this case. Some of them local, some of them national, with, some of them have hundreds or thousands of members, others have hundreds of thousands of members. So this case has captured the public's attention.
We'll just keep scrolling for a minute. I think this goes on a little bit.
Sure. These are all groups that you're looking at right now. So these are just Facebook groups that have been created talking about this case. These are videos.
These all popped up from that one search term.
No, I don't think we need to advertise all these, honestly.
Okay,
We've been trying to protect from this kind of stuff.
Your Honor,
I'm aware of it. I don't look at it. I don't read it. We know it's there.
may we take a brief break, Your Honor?
Sure.
Quick break.
Go off the record.
Interesting. Okay, let's see how long they're going off the record. They said, let's see. Interesting. Huh. I wonder how long they're on a break. Whoa, look at that. This is their court computer screen thingy. Okay, seems like they're on a break for a minute, so let's just see. Oh, this is a long break. Holy mackerel. So this was not a planned break, which is wild. Huh, okay. Wow. Wow, like 2-hour break? What the heck? Okay.
Okay, we are back on camera. Sorry for the
Crazy long break.
disruption about that, but we're going forward now. Okay, Ms. Taylor?
Thank you, Your Honor. May I attempt to share my screen?
Yes.
She said attempt to share her screen. That's funny.
All right, Dr. Edelman, let's talk about community attitude survey. What is that?
Well, it's a survey designed to estimate opinions and experiences in greater populations, which in this case are the prospective jurors in Latah County.
Is there a specific way you set up to do a survey? Can
Yes, of course.
you tell us about it?
Sure. So a lot of the design and structure of these surveys is based on some of the guidelines, professional guidelines from APOR, which is the American Association of Public Opinion Research, and the ASTC, which is the American Society of Trial Consultants, and also 40 years of people doing this. So the way it works is we randomly select people through a random digit dialing approach. So it's a probability sample. Everybody has a known chance of being included. And the first section.
You covered all of this when I read through that really lengthy document. So I'm going to skip some of this in terms of the methodology. Let's just see what the next section will bring us. Okay, let's watch this part.
5%. So this is extremely high. They're pretty much the same. And it's not just a passive familiarity with the case. It's not that they recognize it but don't know much. You can see people in Latah County reported that they followed the case somewhat or very closely. Almost 70% are closely following this case. And again, that means they're actively looking for information, passively consuming information, talking about it. So it's a big deal in this community. And there's a presumption of guilt. The burden has shifted. So 67% believe Bryan Kohberger is guilty of murder, and 25% reported that he's definitely guilty. So these are strong opinions. And 51% reported what I call a fixed opinion, where they reported that Kohberger would have a difficult time convincing them that he's not guilty. So the burden of proof has shifted on the defendant to prove his innocence. And that's undermines due process. That's not how our system is designed to work. And also on the question of sentence, you can see that 52% believe that he should be sentenced to death.
When I look at this slide and I look at the pre-judgment, I'm guilty of murder, and am I using that term right? Pre-judgment means somebody's decided before we ever get anywhere near trial that Mr. Kohberger is guilty of murder. When I look at those numbers, it's higher in Ada County. And it's not a secret to anybody in this room that our argument is to move this case to Ada County. Does this seem counterintuitive when I look at the pre-judgment rate and it's higher percentage-wise in Ada County?
Yeah, so first of all, in my mind, it's two questions. One is, should the case be moved? Not where, it's should the case be moved? Has presumption of innocence been undermined based on the reasonable likelihood standard, which is less than the preponderance of the evidence? So second question is where? In a case like this, you're going to see high case recognition and high prejudgment everywhere. They're essentially the same in terms of 67%, 68%. But when you look at case recognition and size, population size, you'll find that in Ada County, there's about 16 times more people in that county that have not prejudged, if you do the math. So yes, those numbers look the same for those who recognize the case, but there's a much larger swath of people who haven't prejudged. And it's not just prejudgment that matters. So that's one variable you look at, but it's not just that. There's a host of other things. Extent of case knowledge, connections to the case, been exposed to rumors. There's all these other factors that play in. It's not just one item, it's the totality of the findings, not just one question.
When I move to the other slide, what am I seeing on this slide?
So these are instances just to show how invested people in this community are. So almost 80%, 79% have talked about this case online or in person. And that's where information is spread. So even those who may not closely follow the news are learning about it from their neighbors, from their coworkers, from family, from social media, and all of that. So information is being spread through those channels as well. And you do see big differences there when you're looking at Ada County. It's much lower because they're less invested in this case. It wasn't a shocking incident that occurred in their own community. You see that 32% have watched a show, for example, that Netflix or Paramount show or Dateline or something about the case. Almost 40%, 39% personally experienced high levels of stress, anxiety, or fear during the search for the killer while they were here. So that's very high. And then 45% know someone else who has. And if you look at those together, it's actually about 63% have either personally experienced fear or know someone who has during that search. And that shows like the impact it had on them. And you'll see it later in some of the opens where people talk about, I was scared to walk outside or running to their car from work because they don't feel safe. They can see the house from their office. One person mentions that their wife was scared to go to the supermarket. People talk about they locked their doors for the first time. So it just shows the personal fear and impact this case created in this community that you do not see in large communities.
I have a follow-up question for you on this slide. The statistics that you show us show that the incident of looking at things on social media and Netflix and regular primetime news shows is higher in Latah County. And that's
So again, we've got this, we've got the gist of this. Let's go ahead, jump ahead a little bit, see what's next. And actually, again, all of this was in the document, but oh, this is like the phone survey. Do you guys remember? Hi, I'm Roberta. Do you guys remember Roberta?
what do we see?
So this to kind of give you an indication of the flow of the survey. So this is what I call the case recognition question. And it's developed by reading a lot of the coverage and seeing how the case is commonly described in the language in the newspaper and TV to construct a case recognition item to try to trigger a memory. So if someone answers yes to this question, question 2A, they then go to the prejudgment question. If somebody answers no, we give them a little more information to see if that triggers a memory. If that does trigger a memory, then they go to the prejudgment question. And if not, they go to the demographic question. So we always have 2 case recognition questions. That's a recommendation, again, in the ASTC professional guidelines. We usually pick up 1 to 2% when we do that in most surveys.
Does this question come after your earlier questions to get them to take your survey, the introduction and information questions?
Yes, it's actually even deeper. So you get the introduction. First, you get why we're calling, and then you go through screen of questions, and then you're given an instruction about you. There's no right or wrong answers. You can always say, I don't know. You can always refuse. Your answers are anonymous. Then they answer, I think, 3 or 4 general criminal justice questions, and then they get to this question.
When you say the prejudgment question, are you talking about the media items stuff? Is that the same thing you're talking about?
Prejudgment is whether or not you believe a defendant's guilty of whatever the crime is. This is before any of the media items. You would never put those media items and then ask if you think they're guilty, because then you'll create response effects. Like maybe they didn't know that item and you just gave them prejudicial information, and now I think he's guilty because you just told me he confessed or whatever thing it is. Like, you wouldn't want to do that.
Is that why the survey is designed that way?
Yes.
Okay.
All right.
I'm going to jump forward a little bit. Actually, I might jump forward to the argument because, again, we've actually covered all of this in the document. Of all of this from the presentation is, yeah, I mean, it's all what we've seen in the document that I covered. So, final opinions. We'll go right here. How about that?
That people think the community would have if he's acquitted. That's particularly concerning. We know from the data that jurors have closely followed the case. They've talked about it. They're familiar with prejudicial details. I think that the presumption of innocence has been undermined and presumption of guilt prevails in this community. And I think the pre-existing attitudes and opinions will influence how people process evidence. So even if the same information is presented at trial, there's a big difference in terms of jurors being exposed to that for the first time. I don't know about the DNA evidence. I don't know about the videos versus a juror being exposed to something that they already know, where they're just confirming what they already know. I already know about the DNA evidence. It's just triggering a memory of what I already recall. And I'm processing this information through that filter, but it's consistent with what I believe and I already know. And it impacts how they see government witnesses and how they will view and evaluate defense witnesses. And I don't think voir dire is an effective remedy, given the research I've done, my experience doing jury selections, and the nature of how memory works. So taking all that combined, I think it's appropriate to change that.
Thank you. I don't have any other questions, Your Honor. And Edelman can kind of keep the statement.
Okay, thank you, Ms. Taylor. So this would be a good time to take a break.
Sure.
And we'll come back at 3:20. Thank you, Dr. Radford.
Okay, so they're going to take another break and then it'll be cross. So, Nito, let's jump ahead.
This is State versus Kohberger, case number CR 29222805. Kohberger still in the courtroom along with counsel and also counsel for the state. And Mr. Edelman is ready for cross-examination. I
Well,
believe,
yeah, you know,
and you're still on your oath, so go ahead.
And actually, Your Honor, the state has everything it needs from Dr. Edelman, so we won't be doing any cross.
Okay, may this witness be excused.
You may, Your Honor.
Holding
Okay,
alcohol.
thank
And
you.
on
You're
to
free to
argument.
stay, free to leave.
Guys, Eureka. I don't know why I just said that. I don't think I've ever said that in my life. On to the argument. No cross. Holy mackerel.
Thank you. Appreciate for you
Cool.
being here.
It's our lucky day.
Okay,
On to the argument.
another witness?
Oh.
Yes, Your Honor, our last witness is Dr. Dahir.
I spoke too soon. Sorry, guys. There's one more witness, but it does not look like they are a very long witness. So
There. Okay, I thought
more
maybe Dr. Dare was going to be rebuttal to the state. No,
Your Honor, we disclosed Dr. Dare twofold. First, to talk to the court about the survey instrument itself, and then to provide rebuttal testimony. Part of that is going to come based on the state's objection too. So I don't know if the state has any witnesses to call, but we'd ask that she stay for that if that's the case. as
Okay.
well.
so Dr. Dare, line it up. Please
All right,
face,
here she comes.
face clerk, raise your hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
Thank you, ma'am. Please have a seat, and then once you're seated, please state your name and spell your last.
Yes, Veronica Dare, Dahir.
Thank you. Ms. Taylor, go ahead.
Thank you, Judge. Good afternoon. All right, let's start with your occupation. What do you do?
I am the director of the Grant Sawyer Center for Justice Studies at the University of Nevada, Reno. I'm also the director of survey operations for the Nevada Center for Surveys.
I believe this is the one that actually had the most atrocious typos, if I recall.
Evaluation and statistics, also at the University of Nevada, Reno.
Do you also do consultations outside of your role with the university?
Yes, occasionally.
And is it in that capacity that you're here today?
No, today I'm here independent of my role at the University of Nevada, Reno. I am here as an expert consultant, and that is independent of my work at the university, although my testimony is based on my previous experience, knowledge, and education that I received at the university.
I'm going to talk a little bit more about what you do for work, but let me back up and find out about your educational background.
I have a bachelor's degree in psychology
Okay, I'm gonna skip
and a
some of this.
master's and PhD in interdisciplinary social psychology.
Whatever.
From
No,
One, as I mentioned, is the Grant Sawyer Center for Justice Studies, and the other one is a survey lab. I also teach in social psychology, psychology, criminal justice research methods, natural sciences. We do research on justice-related topics broadly defined. My background
going
relations
strong.
as well, including people in charge of multiple research projects,
Still going.
and I've been doing that role since I've been a graduate student and even before that. So not before graduate student. Well, I did recently
my God.
the effect of Dahir.
Oh my God.
I won't do that to you, so because I can shoot off all the acronyms, but
Oh, please don't.
yes,
Is that both designing surveys and then critiquing
New
surveys?
question.
yes. So we have done numerous projects, as I mentioned. You're probably going to ask me, so I'll just say it. We have published in academic journals.
No, she's still doing. I have to say, Ann Taylor's hair looks flawless, and I'm gonna skip some more of this because my God.
I personally have published on
My
different
God.
4 projects, and those are basically a lot of evaluation projects, research.
Of both.
Yes, I'm a member of both organizations.
I want to know
Okay.
why people do surveys. It sounds like you've had
Oh my God. Why?
A couple of them, we did a survey for the Nevada Department of Transportation, specifically looking at highway maintenance in the state of Nevada, asking residents about their opinions on highway safety. We did another one for the Office of Traffic Safety, looking at seatbelt usage, car seat usage, and at the time when cell phones came out, texting and driving, distracted driving.
I have to just say, just because they're talking about surveys, I'm one of those people that if you send me a survey, I will take it. I actually love taking surveys. I'm a weirdo though.
Behavior. So we've done surveys on those. I'm currently doing a survey with DETR, which I had mentioned, DETR, on foreign labor wage surveys, where we're looking at the farmers in the state of Nevada on whether or not what their wage, the prevailing wages in the state of Nevada. There are many reasons in the justice system. For example, we do surveys on judicial, attitudes, jury attitudes, decision making, looking at specific attitudes towards specific crimes. I did a survey on human trafficking. We did another survey on victims of crime. I could go on. Marketing research. You guys have been asked to take many surveys about projects that you, I mean, not projects, but things you bought, things that, you know, they ask you to evaluate restaurants. You get surveys all the time. People do it, as you know, in the election that's coming up. I'm sure you guys have got bombarded with many surveys. Not all of those are valid, by the way. They're called push polls, but anyway, that's something different. But there are lots of surveys that reasons people do surveys, primarily to make decisions and to form policy, to reform policy, to make changes within their organization. And in this case, to assess community attitudes, bias, and the potential impact of pretrial publicity.
Sounds like it's to gain information, and that's in order to make a decision.
Yes, decision making, and especially within the organizations, and then related to policy. We do a lot of policy change as well. We've actually presented reports to the legislature for whoever our clients are. Like, for example, the seatbelt survey that we did. We were trying to do a survey of Nevada residents to see if they should have a primary seatbelt law in Nevada. I was involved in what we call
And Taylor was really not carefully and hastily trying to bring it back to the point of why she's there to talk about surveys in relation to this trial, or this hearing rather, and she somehow has brought it back to like not other things. That's pretty cool. Kat says that where he lives, or she, I think it's a he, local mall has an area to give a survey and they pay 10. That's awesome, dude. $10 for a survey? Hell yeah, that's cool.
Assembly Bill 122 in Nevada, where they were looking at.
This is interesting. This witness just wants to talk and talk and talk. I wonder how she's going to handle this. Let's see.
At the assisted living communities within the entire state of Nevada to see if there should be change in those areas.
We don't need any more examples. We need to stay on topic, lady.
So those are some examples. And primarily, like,
Oh my God.
I guess a good example would be the behavioral health,
Why is she still talking?
BRFSS again, by the CDC. The biggest thing that we use that survey for is to look at population health and health outcomes. So we ask questions like behavioral risk that's related to how many fruits and vegetables do you eat in a day? How often do you exercise? We ask about drug practice.
I feel like I'm going insane. Why is she just still talking about this? I'm soaking. Why? Yeah, she's laughing. I don't know why she's laughing. I don't know why she's talking. Like, I don't even remember what the question was, but Ann Taylor was trying to bring it back around. All right, she said, so it sounds like the point of the survey, right? Because initially she was like, what's the point of surveys? And then she gave some answer. And then Ann Taylor, it sounds like the point of the survey is to gain information to make a decision. And that's a beautiful way to say it. Why? Because they're here to talk about how the surveys help them gain information, make a decision about a chain of venue. And then she's so that's what she says. She sounds like the point of surveys is to gain information to make a decision. And then she just starts talking, and then she's still talking. I'm like, what? That was a yes or no question. What?
Substance abuse, sexual practices, whether or not they've ever been told that they've had diabetes or a heart condition or asthma. So those are examples. So we look at the indicators that could predict or have outcomes on the population health. So outcomes, basically.
I heard you mention community attitude surveys. Are you familiar with those?
Yes, I mentioned a couple of the examples that we have done community
No.
attitudes. And that's basically measuring
No.
attitudes of the community on specific,
Oh my
a
God.
specific target population on specific measures of interest.
Did you have an occasion to review the community attitude survey that Dr. Edelman conducted
Yes, I did.
relating to venue issues?
Yes, I did. Excuse me. Hold on. I have these
Okay,
exhibit F and F1. It's just my declaration and my expert report that I've already provided to the court.
okay. And I can see you just placed those face down. If you need to
Yes.
place them back face up, will you let me know?
Yeah, I will. Sorry. What was the, can you repeat the question?
That's okay.
Oh my
I'm
God.
wondering if you had an opportunity to review the survey work done and conducted by Dr. Bryan Edelman.
Yes, I have.
Okay. And do you have an opinion about whether that survey was conducted in a valid way?
Yes, I do.
What is your,
In my opinion, it was a valid survey.
That was weird that she answered that, yes, I do. And then she didn't even elaborate. That's so weird. So her whole job is to be like, was his survey valid or not? That's the point.
what do you base that opinion on?
So there are standards and professional code.
I'm going to skip past it because, again, all of this was in the memorandum, but let's see if there's any cross on her. That would be interesting.
Was the questions themselves. I looked at that. And then we also, so in our lab and most labs across the country now, we do like,
To change venue rests on,
Another on argument. Let me go back.
what I could tell, they did follow-ups, they did different call timing, they did callbacks, they did the replicates, they used both cell phone and landline. It is customary practice now when you're looking at coverage validity. You want to
Go forward a little bit because to see if there's any cross, but it seems like they're going to get into the argument here pretty soon. So
get more looked at, and what in terms of asking questions, it could be paper and which is, I think Dr. Edelman alluded to earlier, things like soft refusals. If someone calls up and says, I'm making dinner, I'm too busy,
yep.
Survey, your opinion is that it's a valid survey.
yes, basically it's what I would have done or what we would have done in our survey lab.
Thank you. I don't have any
All
other
right.
questions right now, but hang on, prosecutor.
Okay, thank you.
Thank you.
Any cross?
We have no questions for this witness, Your Honor.
All right.
Great. Thank you.
Argument,
Is it-
guys.
Somebody that was easy.
So
Thank you.
witness the release.
He's a very friendly, smiley judge. I mean, he's just got a very cheerful disposition. I love it.
She may, Your Honor.
Okay.
Argument.
Thank you for being here. It's very interesting.
Let's do it.
Help yourself, yeah, as much as you need.
Thank you.
Thanks. All right,
Fit for witnesses, Your Honor.
no more witnesses. Okay, any witnesses?
None for the state, Your Honor.
Okay, we prepared for argument?
Let's do it.
Okay.
Oh my God, we
Thank you,
said that. Did you guys, y'all? Did you guys hear that? We said that at the exact same time. That was that was weird. Oh my God. That's weird. Crazy.
Your
All
Honor, the decision to change venue rests on what you've heard today and the court's determination that there's a reasonable likelihood that all of the media coverage has impacted the impartiality of a Latah County jury. That comes from Paul and Shepard. Your Honor, it's important to think of that standard in light of the Constitution of the United States and the state of Idaho. Mr. Kohberger has a constitutional right to a fair trial by an impartial jury. And to guarantee that, this court must change venue. Your Honor can look at the media coverage in this case and know that it's prejudicial coverage. The amount of coverage is a huge amount of coverage. The kind of coverage is prejudicial coverage, and it's had an impact on the Latah County potential juror. The court can see actual prejudice by understanding the results of that survey. Reading the hundreds of comments from Latah County residents, you can see that the media has been prejudicial and it's actually prejudiced potential jurors in Latah County. The court can also presume prejudice by looking at this case as it is. It's an extreme case that comes out of the Haddon case in Idaho, and you can presume prejudice in an extreme case. You have heard all day long how much coverage this case garners. It's Latah County, it's bigger, it's the state of Idaho, it's nationwide, it's outside of the nation, it's continuous, it's every day. Social media, books have been written, primetime television shows have happened in this case. It just doesn't stop. And you know that this is prejudicial coverage as well. The state has agreed things that were surveyed are false media items. At least some of them. This is all before the other things contained in the media are subject to admissibility rules, even if they're awkward, subject to cross-examination and full context explanation of what they mean. So you have this coverage that permeates the community, bigger than the community, the state, bigger than the state, the nation, and this is an extreme case. The court should think about things that have happened in this courtroom too, when considering whether this is an extreme case and the amount of prejudice that exists. This court has issued courtroom rules to determine who can have a camera, where a camera can be. The court on our motion limited things and finally removed cameras from this courtroom, and the court right now is live streaming. That doesn't take care of all of it though. The live stream is captured and replayed almost in real time, if not real time. Everything that happens in this case
but that's public record.
is on social media, and all kinds of things that don't happen in this case run rampant in news stories and social media stories and impact all of the jurors. It is particularly important when you're considering this extreme case to look at the size of this community. You heard a lot about that today. You heard how bias is created. And when you think about this little community and all of the people that spoke out early on about this case, that's how the bias starts in this case. People in this community have a lot of ownership in the case as well. They're connected, to the case by being related to or knowing people that conducted the investigation. They're connected to the case by knowing the community leaders that have spoken out about the case. They're connected to the case by the relationship with the University of Idaho. That's a pretty tight connection. And that is how you have to think about the human bias that exists and how it cannot be fixed if we get to jury selection. Your Honor has to look at the content and know the content of the media and know that there hasn't been positive stories about Bryan Kohberger. It's negative stories. There's not a media story talking about Bryan Kohberger's right to be presumed innocent. There's not a media story
I
talking.
mean, I know I'm not a media story, but I do that. You know, it's important. Hi, Cece, glad you're here. You know, yeah. Again, well, I don't even know what the thing is, like LawTube, and not that I'm calling myself LawTube, but LawTube or LawTube adjacent. You know, on YouTube, it's really a different situation than what you get in the mainstream media. So, you know, I think she would probably be pretty pleased with the coverage that most people, in terms of, again, LawTube adjacent. I mean, I think she'd be pretty pleased with what people are saying, you know.
About Bryan Kohberger being loved by his family. Nobody's talking about the good grades he achieved all through his undergraduate career.
Okay, but that we don't know because we don't have access to that because of the gag order. How would we know that though?
And graduate programs. Nobody's talking about the dog that he loves and helped train. It's all negative. It's false. It's misleading. It's stuff that's rumor and never coming into court. There are things about his character that are just untrue that are out there.
His dog's not
When you have
either
this much information surrounding the case,
likely.
it's an extreme case and it's all over the place. I don't want the court to think all this social media happens and it's not centered in Latah County and think that's okay, because it's just not. There's plenty that's centered in Latah County. I'm sure the court remembers where we started earlier today with the two pie charts that we were shown by Crusoe this morning. One talks about how big the coverage is in Latah County that projects into Latah County compared to how small of a piece of the pie of the whole population in Idaho that Latah County is. So that's a lot of coverage directed into Latah County. And that's the stuff. Those are the news stories, the nightly news that's coming into Latah County residents' TVs. That's their newspaper that they're going to get in the morning. But that's not all. Latah County has as much access to primetime news stories, as much access to Facebook groups, to different podcasts, to watch things on YouTube, to buy books containing this information. They have as much access to do that as anybody else. So you have to recognize how big the case is, how much coverage there is, and just how prejudicial the coverage is. You understand that, we understand that, Lauren, from Dr. L. O'Leary this morning, when she talked about bias. So having that as a backdrop and thinking about the survey results that we just talked about, you can see that there is a huge correlation to the few media items that could be tested and prejudged.
I will say, and you guys know, for any of you who've watched the coverage I've done this, I freaking love her. I think she's amazing. But this is not her best day, I feel like, so far, because they've got a lot of really great arguments that they can be making. And the judge has already heard this, what she's been saying so far. It's already been said a bazillion times. Like why? You know what I mean? Like there's other good points to be had here. So let's just see. I don't know why she's kind of starting with this, but we'll see.
Of guilt for Mr. Kohberger. And those are people in Latah County. You can see the case connections that are bigger than the other counties, and they just don't go away.
You're not hearing from Spice.
You also should be aware that the coverage doesn't drop off. It's not going to stop. It may peak and it may dip a little bit. It comes right back up. You can expect that will continue. We have a pretty good schedule of hearings coming up for pretrial motions. The court issued a scheduling order a couple of months ago. And so you can expect that the interest in the case is going to pop back up every single time we have one of those hearings. And that's a lot of media coverage, and people in Latah County are going to see it and read it, and they're going to continue with their opinions. So what do we do? What do we do about it? It's tough. It's really tough in Idaho. There is a lot of case recognition.
And that's the thing, Kat, is like your question here is exactly what I've been saying, which is where you have to be careful, because if, these are attorneys, right? And if they really hammer hard this idea of like, look at how fucked the jury pool is, like, voir dire is not going to help anything. And like, it's fucked everywhere. And like, if you really, and like every time that they say things like voir dire is not a solution, voir dire is not enough, blah, blah, it's like, because if you really lean into that, it's like, that's exactly the thing is it's like, well, then there's no point. What are we even doing? Why are we even having a trial? Right. Kind of to the similar thing as what Kat Randall's asking here about, you know, if a lie can go around the world before truth can get its pants on, how can we have an impartial jury? So, I mean, yeah, I don't know. It's tough. It's tough. I mean, especially because, you know, as we know, we can't get inside people's heads, right? And there's like implicit bias, and yeah, it's tough. But I think that keeping people informed, I mean, the problem is part of this is just up to people's discretion. It's their own personal, you know, perspectives and what they're going to consume, right? Because some people care about nonsense stuff, in my opinion, you know what I mean? Like, and then others actually want to be informed and actually want to get good information, and that makes a difference. I mean, we need more of that in the world for sure.
And there's prejudgment in Idaho, but there's hope. When you look at the survey and you recognize that in other parts of this state, people don't recognize as many media items as they do in Latah County. That's good, because that links right to prejudgment. So that's good. That's hope right there, that we can find a jury somewhere in the state to give Mr. Kohberger his right to a fair trial. It's also a much larger population, so the impact on people sitting on the jury would be much smaller. Imagine with me that we are here in June of 2025, and we're here, and we've seated 16 or so people over here. You're going to recognize some of them. People that sit in the courtroom in our audience that want to come and listen to the trial are going to see them. Even if they don't listen to the trial, people are going to know whose car leaves their driveway every morning to get to the courthouse by 8:30 for 3 solid months. And those jurors that sit over there are going to feel an immense amount of pressure to answer the call of the community to be safe.
Again,
you can read
those are the weakest points. She could have. You're supposed to put your weakest points in the middle. You know what I mean? So I don't know.
Comments about what people in this community think about Mr. Kohberger and what they think would happen if the jury found him innocent. It's hard to imagine that one of those jurors who all of a sudden said, you know what, I'm not sure, and listened to more evidence and said, I'm really not sure. I don't think he did it. Are they going to be brave enough to do that, to write not guilty, to say not guilty, and to stand their ground? That comes right to impartiality, that the court has to be sure that that's not going to happen. And you can't be sure that there's a way to pick an impartial jury in this community. In Ada County, we don't have that. We don't have Canyon County, we also don't have that. Those are jurors that are not from this small, close-knit community. Those are jurors who aren't going to run into a police officer that investigated the case at the grocery store, or maybe somebody from the prosecutor's office at the jazz festival.
One thing I will say that bodes well for this change of venue potentially being granted is that for both Lori Vallow and Chad Daybell, they were both granted a change of venue again to Ada County from, I always forget which county they were initially from. Hold on. I always forget the original venue. Hold on, let me look it up. I'll probably remember it as soon as I go to search for it. But they were granted a change of venue, both of them. Oh my God, what is it? Starts with an F, I think. Oh my God, what is it? This is gonna drive me crazy, guys. Hold on. Idaho County. Let me just find this real quick. Does it start with an F? Not Idaho County, Idaho counties. Anyway, so yeah, so they were granted a change of venue, both of them, to Ada County. So that makes me wonder if, you know, it just, I would imagine, you know, if they Fremont, I was right about that. Fremont, there it is. Okay, good. So I would imagine that if they were successful, then probably this will be successful as well. So, but we'll see.
At the college, there are people who don't have those connections. The other difference that I think is really important to think about too is that the location, the connection to the house where this happened. That has been a pretty big deal in the community and wider but in the community about whether the house should remain standing through trial or should be torn down. And there's been an awful lot of publicity about that. People in this community have an opinion one way or the other. We aren't going to know what their opinion is, but they're going to bring that into the courtroom. People in Ada County do not have. And why Ada? Why not Canyon, or why not Bannock? I think that's something that we should talk about. The easiest one to talk about is Bannock. The numbers look a little better there in a lot of regards, but it's a smaller community as well. And so I think that there's a danger that if the court says, I'm going to change venue and we're going to
I
Bannock
think
County,
that's one of their best things is saying, like, you know, they need the larger jury pool. That's really what it comes down to. And I'm sure that's kind of why it got granted for Lori and Chad, that larger jury pool, you know?
I think there's a danger with that small community. There could be more interest all of a sudden, and we may run into a bit of a problem. So that's why I'm not here telling you Bannock County, but if you tell us Bannock County, I think we have a lot better shot at seating an impartial jury than we do here in Latah. Canyon County is the second largest. And Your Honor, honestly, if the court says, let's change venue, let's go to Canyon County or Bannock County, I think we have a better shot at getting an impartial jury. But we picked Ada County specifically because we're aware of the structure of that courthouse, the way it's set up. We're aware that there's at least some statewide precedent for moving these big cases to Ada County. And we're aware that it would be easier to get our jurors to and from that courthouse in a way that they wouldn't have to go through the media. They would be kept private and in secret and secure.
Yeah.
It makes sense to focus on Ada County for a lot of those reasons. Your Honor, we're mindful that that's a lot of miles away from here. But at the end of the day, the interest that we have is to protect Bryan Kohberger's constitutional rights. His right to a fair trial is as important as our right to free speech, our right to bear arms, our right to be free from unreasonable searches and seizures. And the right to a fair trial cannot happen in Latah County. There is way too much media coverage. It is biased media coverage. It has impacted the potential juror, and it causes bias in the potential juror. This is a tiny little community, and this case needs to move where there's a chance to get jurors that haven't prejudged guilt of Mr. Kohberger and will have the ability to be anonymous and not known by everybody else in the community. The pressure to convict here is great, and it won't be in Ada County. The venue.
Her hair looks great. All right.
Thank you, Ms. Taylor.
We're going to have some
Dave?
other
Thank you, Your Honor.
for the state. Who did he say it was? Hold on.
The venue needs to be changed.
I forget this other attorney's name.
Thank you, Ms. Taylor. Ms. Beatty?
Thank you, Your Honor.
Miss Beatty, right. Hold on, let me find her.
Your Honor, the case law in this case just does not support a change of venue, given the evidence that the court has before it. The state does not disagree with counsel on what the appropriate standard is. The appropriate standard is that the defense has the burden of showing a reasonable likelihood that the defendant's ability to get a fair trial is going to be diminished as opposed to some other county, or put another way, a reasonable likelihood that pretrial publicity will deprive him of a fair trial. So in looking at the evidence the court has before it, we can start with Exhibit C. Those were the charts presented by TrueScope. And we can see in those charts that for at least 6 months on one of those line graphs that compared Ada County and Latah County, Ada County had significantly more coverage than Latah County. And that more recently, in the past couple of months, that line graph comes together again, and they're just a couple points off. The fact is, Your Honor, this case has media coverage everywhere. That is something that was acknowledged by the defense, and that is something that is abundantly clear in these surveys. So looking to Exhibit C, comparing Latah County and Ada County, it is clear that this could easily be a back and forth scenario where at some points Latah County is higher and at other points Ada County is higher. And it almost looks like we may have recently been headed in that direction as recently as a few weeks ago. In looking at the survey numbers, Your Honor,
Y'all,
like to talk.
Prosecutor Santa looks like he's got a whole canteen of coffee in front of him. Actually, I guess Ann Taylor does also, but anyway. No spicy Santa this time, it seems like, unfortunately.
About what the numbers from the survey actually say. And I'd like to start by looking at Defense Exhibit. Defense Exhibit F1, Dr. Dahir. We don't dispute any of the testimony that she gave today. We don't dispute anything in her declaration. And one of the things in her declaration that she discussed was a 5% margin of error in surveys such as this with 400 survey respondents in a population within the range of our population in Latah County and in the population of Ada County. So if we're talking about a 5% margin of error, according to the defendant's own expert, and we're looking at case exposure in Latah County of 98% and Ada County of 93%, those communities are within the margin of error. Looking at presumption of guilt among jurors who knew about the case, Latah County, 67%, Ada County, 68%, Canyon County, 69%, and Bannock County, 76%. Latah County, Ada County, and Canyon County are at best within the margin of error. And if these results are to be taken literally, Latah County has the lowest number of jurors who knew about the case who are going to presume Mr. Kohberger guilty. Now, when you zoom out and look at the survey results for presumption of guilt among all respondents, Latah County is at 66%, Ada County is at 64%, Bannock also at 64%, and Canyon at 62%. Again, you're within this margin of error here. I would also point the court to the fact that jurors among the total sample size who had no opinion about this case, potential jurors, survey respondents, Latah County had the highest number of folks who reported having no opinion about this case at 17%. Ada County, 12%, Canyon 13%, and Bannock at 9%. And then again, jurors among the total sample who had no opinion about Bryan Kohberger, Latah County 29%, Ada County 25%, Canyon County 23%, and Bannock County 24%. Again, we have the highest number of survey respondents in Latah County saying that they have no opinion about the defendant. When you zoom out, this is the big picture. These are the questions that matter. The question is, which community is the most likely to give Mr. Kohberger a fair trial? We can split hairs and say, well, if this person knows this media item, then they're X% more likely to think he's guilty. That's not the big picture. Those are trees in the forest, but we're ignoring the forest.
Trees in the
And
forest,
if you're looking
right?
at the forest is which community has the least amount of bias. And there are obviously some personal connections in Moscow and to the University of Idaho. The state does not dispute that. We believe those can be dealt with through other measures short of venue change. But when it comes to bias itself within a community, the court can take this entire 300+ page document of all of the survey responses and look at these surveys and see
You and I covered.
that the pervasive media coverage across the entire state has simply created some complications and difficulties. Those are not unique to Latah County. The more productive conversation to have is how can we craft questionnaires that will ask jurors factual questions that help us identify sources of bias? For example, are you employed by the University of Idaho and how? Or did you know one of the victims? Things like that are factual that will allow us to then follow up and ask more questions. And frankly, Your Honor, the state would be willing as we approach trial to engage in good faith discussions with defense counsel and the court about potentially just excusing some jurors who are too factually close to the case for cause from the outset. We're willing to have that discussion. Another thing that the court can do that would address some of the concerns that were testified to regarding bias and social pressures is to allow potential jurors to have individual voir dire and outside the presence of other jurors and outside the presence of cameras or audio recording that are being live streamed. In this case, it's going to be critically important that potential jurors who come to jury duty feel like they can give honest answers and feel like they can be forthright. And in order to do that, I think individual voir dire would be very appropriate, and the court has that option available to it. I think another possibility that the court should consider, particularly after looking at Exhibit C and those line graphs where we're talking about peaks in media coverage, is sealing some potential hearings coming up. And the defense may not want to seal certain hearings for good reason. We're not asking the court at this point to seal all hearings going forward, but the state believes that there may be certain evidentiary hearings. For example, if the state files 404B notices or motions in limine related to the evidence, some of that information might be extremely prejudicial, and the state would agree to seal hearings where prejudicial information is going to come out in that hearing. And that too is a tool that the court has before it to alleviate some of those peaks in media coverage, because of course, part of the court's consideration is going to be the intensity of media coverage over the life of the case. And so one way that the court can address that is by sealing certain hearings, and the parties can use good faith and seal certain motions or briefs addressing prejudicial information temporarily until the trial is complete. When we're talking about bias and individuals who come to court for jury selection, I think it's important to remember that we have to deal with what the law says. And what the law says is that voir dire and jury selection is the appropriate process for ferreting out bias. We don't get to hand wave the jury instructions that are based in case law and that are handed to us by the Idaho Supreme Court. We don't get to hand wave those and refer to them as indoctrination and act like all potential jurors are going to come to court and lie, that they can't be trusted. Now, certainly there are some human biases, but a good voir dire is the tool to address those. And we don't get to just burn the system down. That's not what we're here to do. We have to use the voir dire process. I would also point out that when we're looking at, well, actually, Your Honor, let's talk about some numbers. Let's assume, we've heard a lot about the Daybell case. Let's assume that this court decides to summon 1,800 jurors. Let's assume that this court decides to seat a jury of 12 with 6 alternates, given that it's going to be a very long trial. If this court were to summons a jury of 1,800 jurors, which was the amount that was summoned in Ada County in Daybell, this court could just as easily summons 1,800 jurors in Latah County with a prospective jury pool of 32,000 as a court could summons 1,800 people in Ada County. It doesn't matter that Ada County's population is 16 times higher than the population in Latah County, because in Ada County, the court, if the court moves this trial to Ada County, is not going to say, well, we're in Ada County, I guess I'll summons in 20,000 jurors. That's not how it works. This court could just as easily summons in 1,800 jurors in either location. And if this court were to summons 1,800 jurors, only 1 in 100 would have to qualify to sit on a jury in order for this court to proceed to trial. So if you look at that 1,800 number and you look at some of the survey numbers, let's look at total prejudgment. Total prejudgment by total sample. 17% of Latah County jurors had no opinion on total prejudgment. That sounds low, but when you look at it out of a jury pool of 1,800, that's over 300 people walking into this courthouse with no opinion about the case. You look at the question, given what you have read, seen, or heard about this case, would Bryan Kohberger have a difficult time convincing you that he is not guilty of murder? 19% said no, 16% said no opinion. You add those up and you have over 600 jurors out of an 1,800 person jury pool who would answer that question in that way. What is your opinion of Bryan Kohberger? No opinion, 29%. That's over 500 jurors that would come into this courthouse with no opinion of Bryan Kohberger. A large jury pool is a solution to the media coverage in this case, and this court is going to have to summon a large jury pool wherever this court holds this trial, whether it's in Ada County, whether it's here, whether it's in Bannock County, or whether it's in Camden County. And frankly, Your Honor, as we move toward the issue of convenience, if anything, these survey numbers being so close to one another and so tight with each other should tell the court that if the court did determine that a venue change was appropriate, if the court made that determination, Kootenai County or Nez Perce County would be a far more logical choice, because those are geographically closer and the state would not have to pick up and move all of its evidence for 3 months down 300 miles to Boise. The court would now have to move its entire court staff. People could still go home. There would be less witness travel expenses. So if the court decides to change venue, the court should look at more convenient options closer to Latah County. Either Kootenai County or Nez Perce County would alleviate some of the concerns laid out by the defense about the connections to the university or the connections to Moscow itself. But again, even looking at the survey on those issues of connections to Moscow or connections to the university, 39% of folks in Latah County visited or walked by the home where the murders occurred. 60%, nearly 60% didn't. That means that out of a jury pool of 1,800, over 1,000 people would not have gone by the home where the murders occurred. Are you or a family member, student, or employee at the University of Idaho in Moscow? 75% of folks in Latah County said no. That's 1,300 out of 1,800. I don't want to beat a dead horse here, Your Honor, but a large jury pool alleviates these concerns so much better than simply moving venue to another locale where the public sentiment is so close that it's within the margin of error, or if you're taking these survey results literally, worse. That makes no sense, Your Honor. The other option that the court has available to it would be to bring in a jury pool from Nez Perce. Again, the state does not believe that a venue change is warranted given the evidence that the court has before it. But if the court were persuaded that a Latah County jury could not successfully be sat in this case, the court could bring in jurors from Nez Perce County. Lewiston is approximately 30 minutes away. It would certainly be a longer drive for them, but the court could deal with that in scheduling and make those accommodations. It has many months to prepare to do that. moving to the convenience issue, I think it's important to note that Latah County is not a tiny little community. Latah County might be close-knit, but it is not a tiny little community. Latah County is one of the top 25% of most populated counties in the state of Idaho. It's 11th out of 44 counties in Idaho. There are 32,000, according to Dr. Edelman, jury-eligible citizens in Latah County. It is not so tiny that we could not summons in a jury of 1,800, a jury pool of 1,800 folks. Since the convenience argument focuses primarily on Ada County, that's what I'm going to address today. So starting with the size of courthouse and the ability to house parties and court staff, it's already built into the Latah County courthouse for the court to have a place to go, for the court's employees to have a place to go, for court staff, for the court staff attorney. All of that is built into the Latah County courthouse. Unlike moving to Ada County, where the courthouse would have to accommodate the court and all the court staff. Similarly, the prosecutor's office and their staff already built into the Latah County courthouse. No separate accommodations would be needed. The defense will have to have accommodations wherever they go, and certainly they are entitled to privacy and accommodations that will allow them to prepare for this extensive trial. They absolutely should have that. But they are going to have to find those accommodations regardless of where this trial is located, unless it does get moved to Kootenai County. And so keeping this trial in Latah County would be a lesser burden on the Latah County courthouse in the sense that they would simply have to find accommodations for the defense team rather than finding accommodations for everyone. As to juror space and security, as well as the argument of overall security, it is true that the Ada County courthouse has a precedent of handling large trials. And it is true that Ada County does a very good job with that. But the reason Ada County does a very good job with handling these high-profile cases with security, with court staff, with organization, with getting jurors in and out in an organized fashion, the reason Ada County does a good job with that isn't because Ada County has a physically bigger courthouse. It's because Ada County has diligent, competent, and professional staff. And I have every reason to believe that with the 9 months we have until trial, that this court staff here and security could also have the time to prepare and make operation plans and all of the things that go into having a trial of this magnitude. I have no doubt that they can accomplish that with careful planning and preparation over the many months between now and trial.
I have to say, I've not been super impressed thus far with, a lot of the argument from the state and whatnot, I guess, so far in hearings. But I think she's doing a really good job. I do. So
it is also my understanding that there is a means to bring jurors securely into this courthouse outside of the public view. Moving on to the cost of travel expenses, counsel referenced the cost of transportation to and from the airport and correctly noted that the Spokane airport is considerably further from the Latah County courthouse than the Boise airport is from the Ada County courthouse. That's absolutely correct.
So as we continue wrapping up their argument here, because the the hearing's almost done. Let me know what you guys think in the chat. First of all, do you guys think that this should have a change of venue? First of all, that's the first question. Question number one, do you think this should have a change of venue? Question number two, what do you think Judge is going to do? So let's start with question number one. What do you guys think? Do you think that they should change venue? Just your own personal opinion, right? For question number one.
However, the Lewiston airport is a shorter drive, again, about 30 minutes, and does connect to some major airport hubs. That would be another option. But even taking into account that there may be some additional rental car expense for the few out-of-state witnesses that we're going to have, that would be negated and then some by transporting all of the local witnesses from Latah County down 300 miles to Boise, by paying for accommodations in Boise for the court and court staff, the prosecutor's office and prosecutor's office staff, and the many local witnesses that will be testifying in this trial. There's also the logistical issue of transporting evidence for a 3-month trial, the chain of custody issues, the evidence tech from the Moscow Police Department, and it's my understanding there's only one, taking him out of his role up in Moscow here for 3 months and having him in Boise, trying to manage this evidence in a location that we would also have to arrange for, and dealing with the chain of custody issues, transporting the evidence back and forth. I think the court can also consider, since this is a pretty broad standard on the convenience side of things, the effect of prosecutors and law enforcement being away from the community for up to 3 months. And I think the court should also consider the nature of Latah County itself. The infrastructure of Latah County, and specifically Moscow, which has a university of nearly 12,000 students, is that this community is tailor-made to expand and contract with the rhythm of the school year. So this isn't going to be a situation where there aren't enough hotels or aren't enough restaurants. This town, as well as neighboring Pullman, which provides additional accommodations, is designed to handle large influxes of people. That should not be any concern for the court at all. Again, we are not talking about a tiny community here. We are talking about a mid-sized town that's on the, frankly, on the larger side for counties within this state that can amply accommodate a jury trial of this magnitude, particularly in the summer months where you don't have these major academic events. Finally, since we are talking about the interest of justice in the convenience prong of the rule, it is completely appropriate for the court to also consider the fact that most of the victims' families, not all of them, but most of them, live closer to Latah County than they do to Boise. That means that for them, traveling to this trial, which they will have a constitutional right to attend, and again, we're only asking the court to consider this in the convenience prong, will be much easier for them and more convenient for them than it would be for them to have to travel hundreds of miles to Boise. I think the court can and should consider that factor as well. Your Honor, at the end of the day, these surveys have given the court a factual basis to deny this motion to change venue, and we hope that's what the court decides to do. Thank you.
Thank you, Ms. Beatty.
Is there any more argument?
Ms. Taylor?
Thank you, Judge. Whoever, as I sat and listened to Ms. Beatty talking about all of the prejudicial coverage and how there's a problem in other counties as well as Latah County, it really struck me that everybody knows how prejudicial this media coverage is. Everybody knows that. And that's really the question the court has to answer today. Has there been prejudicial media coverage that there's a reasonable likelihood that it impacts the impartiality of the jury? That it impacts.
That's interesting. That's smart. So she's bringing, so here's the thing. I would say Ingrid Beatty did a really good job of trying to show how Latah County as a venue could support the number of people, how it's not going to be that much more convenient, you know, the cost. She's more about like talking about the venue itself, right? And Taylor's, I think is smart. She's bringing it back to, she's like, Judge, the question before you is about the pretrial publicity, the media, right? So interesting. We'll see what happens.
Mr. Kohberger from getting a fair trial. Don't think about county's numbers. Don't think about Canyon County's numbers, and don't think about Bannock County's numbers. Think about Latah County's numbers. Your first question is, do you grant the motion to change venue to protect his constitutional rights? Don't get mixed up in thinking, well, Ada County's numbers aren't so great either. Maybe Canyon County's numbers aren't so great either. You have to make this decision based on what's going to happen in Latah County. You know, the jurors have been exposed to prejudicial media. You know that there's been an impact on you. You know that that's going to be really hard to ferret out in a jury selection moment. And if you know all that, you have to change venue. You can't just say, well, it's bad in Ada County too, so I won't change venue here. The question for the court is, in the county in which Mr. Kohberger is charged, can you seat a fair and impartial jury? And that answer is no, you cannot. The court then has to decide, what do we do? But answer the first question first. Answer the first question first. And don't be tempted to say, well, maybe we could go to Kootenai County. Maybe we could go to Nez Perce County. We don't have any surveys on them. We don't have any information on them, except we know that Dr. Edelman pulled a couple hundred stories from the Lewiston Tribune and looking at the local media coverage because of the closeness of Moscow and Lewiston. And except that we know that people in Lewiston have the same nightly news as those in Moscow. And by the way, so does Kootenai County. KXLY that broadcasts all the stories on their nightly news, that happens at my house, it happens at Mr. Thompson's house, and it happens to somebody who's from Lewiston too. That's the same news. The difference is the newspapers. And the difference
during this hearing has been making his list and checking it twice because we've not heard him say anything. He's just busy. He's just busy making his list and checking it twice, guys. Don't worry. We'll hear from him probably closer to the holidays. I don't know. I wanted to just say something real quick. So I just Googled the distance in terms of the driving time between Ada County and Latah County, because, you know, that's people that are living in Latah, right? Unless they just get a long-term hotel for like a couple months, they're going to have to be commuting, right? And it's like almost 6-hour drive between Latah County and Ada County. But then for comparison's sake, I Googled Fremont County to Ada County because, again, both Chad and Lori were granted change of venues, and they were from Fremont switching venue over to Ada, and it was like 5.5 hours. So not that much of a difference, right? And that was granted. So, you know, I just have to say my thought is that this is, it can, if I just go off of nothing else but based on what's happened in the past in Idaho, right? From other judges, it was a different judge, obviously, but the fact that it was granted for those trials, I find it highly likely that this will be granted, I think.
is the community connection and what that means in this case. So don't be tempted to go to another county we haven't surveyed. We've surveyed a lot of comparative counties. Stay in the place where your decision rests on what's going on here in Latah County. For sure, when we do get to jury trial, you should do individual court. For sure, we should do a jury questionnaire and we should talk amongst all of us and try to figure out if we can excuse some jurors before they're ever brought in. They should never be on camera. We should try to keep them as anonymous as we can be. Those are all things that we absolutely must
I
do.
mean, always.
I agree with that.
To be the very most
I
protective,
love them.
have to answer the first question. And that question is, we have to get this case out of Latah County. That's an important decision, and it's important to make now. We're 9 months from trial, and we need to have the venue issue settled. We need to be able to have our subpoenas out. We need to have our experts planned. We need to have time set aside. I've got my time set aside, but we need to have our experts be able to get tickets and reservations for hotels. Don't answer all the questions at once, Your Honor. Answer the first one first,
Ooh.
and then think about where it's most reasonable to have the trial.
Wow. Dude, that's Ann Taylor. Dude, that. You guys, that was so smart. Let me back that up. So she waited for him to kind of like say, I agree with you, right? So he's listening and he's like, it's like more like two-way conversation. And she knows that he's listening, and now she's giving him advice. Oh man, brilliant. Let's back that up. Wow.
And it's important to make now. We're 9 months from trial, and we need to have the venue issue settled. We need to be able to have our subpoenas out. We need to have our experts planned. We need to have time set aside. I've got my time set aside, but we need to have our experts be able to get tickets and reservations for hotels. Don't answer all the questions at once, Your Honor. Answer the first one first.
And she's
and
right.
Think about where it's.
That's what their expert said. The expert said the first question is, and that's why that was really smart, because she asked him a question and he gave that answer, and it was like a non-leading question and he gave that answer, and she's using his answer, which was brilliant, because what he said was, it's not about where to change venue, it's if it should change venue first. That's the first question, is if it should change venue. Then the second question is where. So she's quoting that from the expert. Smart. Yep.
Most reasonable to have the trial. Think about the differences in the communities. But answer the first question first. We can't have this trial here.
It's like, this isn't the hugest decision, blah, blah, blah. Answer the first thing, baby steps, right? She's, it's smart.
There's no way Mr. Kohberger can get a fair and impartial jury.
Ms. Taylor. Well, I'm not going to give you a decision now. Number one, I would say this is probably professionally the most difficult decision I've ever had to make.
Did you guys hear that? He said, let me back that up. Wow. Professionally, it's the most difficult decision he's ever had to make. Holy fuck.
Well, I'm not going to give you a decision now. Number one, I would say this is probably professionally the most difficult decision I've ever had to make.
Incredible.
Both sides, okay, have made really
Incredible.
solid positions. Supported that. I know there are a lot of considerations, practical, in terms of logistics
Yeah.
and prejudicial media. So I have some work to do. I'm going to go through everything. Okay, even if I got most of everything, but that's going to take me a little bit of time. And go through the law again, too, including the rule itself and the interpretation of that. So I'll do my best. It's a challenge. So that's probably all I should say at this point. But I listened carefully all day, and I thought there was some really important things to think about, both sides, and that's what I'm going to do. So with that, I will adjourn and take care. Have a good rest of the week. Thank you all.
Okay, so let me pull the other things back up. Hold on just 1 second. So basically that hearing was on August the 29th. So as of this upcoming Thursday, it will be 2 weeks since the hearing. So the question is, I'm wondering when we might get an answer. Now, let me pull this back up. So again, in the wake of the slew of documents that have come out that we're still making our way through regarding the death penalty, this makes me wonder if there's going to be an answer kind of soon, because they've now got to start dealing with all of this, and they're going to have to set a hearing. It makes me wonder, because tomorrow's Monday, if there could be an answer. I don't know. I mean, I can't predict the future, obviously, but it would feel like maybe tomorrow, like it would feel like that might have been enough time, because he'd already been considering this, right? It's not like he's just now starting to consider it. They'd been talking about this, changing the venue for, goodness, months and months and months now. So anyway, but of course, I'm sure he is going to go back and take a look, but so it'll be interesting. So I will keep an eye out for that. But as of right now, what we are, it is a death penalty case. Cece, I know you're new to this case. So so this is what's so interesting, because as we were watching this hearing today, part 2, I've been covering, there's like 14 new court filings that came out in the past couple days. And so I've been making my way through them. And I've learned a lot already just tonight. It's been really, 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 really interesting. I will definitely recommend anyone who's listening now, after the stream is over and stuff, and I'll get the timestamps, definitely worth going back, I would say, and watching the other parts where I covered the documents, because there's a lot of really interesting, like, food for thought, if you will. There's like some really interesting questions that I think come up, and a lot of new information. So definitely a lot to think about and talk about. And so yeah, but okay, so we've covered so far the first 2 out of the 5 aggravators. The first aggravator was the burglary, the circular reasoning one, the one that was like burgling while murdering. And then the second one was the HAC, so heinous, atrocious, or cruel, whatever. This is the third aggravator out of 5. So this is the multiple victims aggravator. And remember, if they can get any of these aggravators struck, that is, because we're going to get to it, but they've got a motion to throw out the entire death penalty as it is, right, to get rid of it. They also have the motion to trifurcate, right? And then they have each a separate motion to strike each of the separate aggravators. These are all different avenues that they're going down to try to save his life. If in fact he gets convicted, found guilty, this all has to be done ahead of time. Imagine the pressure, right? I mean, don't, because it seems insurmountable, right? But God, if you're like a death penalty attorney, like, I can't even fathom it, right? Because you're like trying to save someone's life. I just can't even wrap my head around it. This is them. Like, when you see all these tabs, and I've already read 3 or 4 of these documents and closed out the tabs. This is them attempting to save someone's life. Okay. All right. Motion to strike multiple, again, in the event that he's found guilty. All right. Motion to strike multiple victims aggravator. All righty. So this motion is made on the grounds that murders cannot be aggregated. I think that's supposed to say aggravated in a manner that makes the act of a malice aforethought murder aggravated. Wait, what? That's a wait. That sentence makes no sense to me. Okay, let's just keep going. Issues. Whether multiple victims in a malice aforethought murder case, aggregate is the word. All right. Whether multiple victims in a malice aforethought murder case aggregate for punishment purpose. Oh, I see what they mean, because this is about the number of victims. Okay, let me read this part again now that I understand what's happening, because they're saying the multiple victims, right? Because this is one of the aggravating factors. This motion is made on the ground that murders cannot be aggregated in a manner that makes the act of a malice aforethought murder aggravated. Okay. All right. Argument. The United States Supreme Court has held that the 8th Amendment's prohibition against cruel and unusual punishment made applicable to the states through the 14th Amendment prohibits a state from imposing the death penalty for all but the worst crimes. Thus, the sentencing body must be provided with standards which will genuinely narrow the class of crimes and persons against whom the death. So we already heard about that a little bit in one of the other documents. Multiple victims is, the defense acknowledges, an intuitive aggravator and one adopted by many jurisdictions. Okay. However, it fails to actually achieve a proper focus on the degree of the crime or crimes, and if anything, denigrates the victims. Imagine a killing that fits malice aforethought that first-degree murder as defined by, I wonder if Jay Logston wrote this again, Idaho Code, that somehow fails to meet any of the aggravators in this other Idaho Code except multiple murders. For example, a murderer with no prior convictions for murder did not create a great risk of death to many persons, did not kill for remuneration. The killing was not heinous, atrocious, or cruel, manifesting exceptional depravity, did not exhibit an utter disregard for human life, was not committed while the murderer was perpetrating or trying to perpetrate arson, rape, blah, 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 a long list here of other things. Did not show. So they're listing all the, I think, the things that they're alleging of Kohberger, I think is what they're listing here. Did not show a propensity to commit murder, was not against a former or present member of the legal system. Okay, never mind. They're listing all of the different potential aggravating factors. That's what they're doing. Nor against a potential witness in a proceeding. Yet at least 2 people have been intentionally murdered. If a juror cannot take into account these factors, which encompass motive, method, and the probability of future murders, there's nothing left. There's no way in which 2 murders can be aggregated in a way that makes the act of murder aggregated except to resort to one of the other aggravators. I don't know that I'm following that too much. In point of fact, no other state but Idaho includes both a multiple murder and a propensity aggravator. Interesting. Let me read that again. That's interesting to note. In point of fact, no other state but Idaho includes a multiple murder and a propensity aggravator. That is really interesting. Thus, the multiple victims aggravator is at best a catch-all for cases to which it applies, while at the same time violating the Supreme Court's prohibition for double counting. Although double counting does permit the same evidence to support multiple aggravators, the aggravators must have additional aggravating evidence not included in another. Multiple victims has no additional evidence. It is simply the fact that 1 + 1 makes 2. I bet Jay Logs remembered this. As an aggravator, it is and was predicated on the fact that more than one victim tells us something about the killer and the killing, and what it tells us is necessarily captured in a separate aggravator. To make matters worse, this definitely sounds like Tim. What multiple victims tells us, if we take away the other aggravators, is that a single dead person is not as valuable as 2. I mean, that logic is sound. That's like the way I would try to phrase it. Like that makes sense to me. It's like something I would bring up, The United States Supreme Court has explicitly rejected scoring murder victims on a value scale. Rightfully so. Although the court later overruled Booth, it did not hold that comparing lost lives was permissible, but merely held that, quote, as a general matter, end quote, it does not happen. However, when a legislature literally declares that 2 are worse than 1, that is precisely what happens. Not because it tells us that 2 times the pain is more pain, but because it tells us that a single death, no matter the pain it causes, cannot be enough. Interesting. I mean, I think that's sound reasoning. Similarly to Mr. Kohberger's objection to future dangerousness as an aggravator, the point is not so much that a jury would be wrong to consider the implications of a double or more homicide when deciding the appropriate sentence. However, if the question is what sort of circumstances elevate a particular case such that death may be imposed, the fact that there is more than one victim tells us nothing about the culpability of the offender. True. More information is necessary to come to the conclusion that death is appropriate. Conclusion. Based on the foregoing and argument to be presented at the hearing hereon, I can't wait for the hearing. This court, blah, blah, they're granting, and there it is, J. Weston Logston. I knew it. It's so funny. I can, you get to know the writing style of these attorneys, and it's funny. Yeah, I mean, it's very ew. And honestly, if you want ew, again, when you go back and hear some of the stuff I read earlier, it's hard. It's hard. It makes me, it's like, oh my God. Yeah. Okay. It's tough. So, yeah. Okay. So what's the next one? So now we have the 4th aggravator, right? Wait, am I out of order? Hold on. These might be out of order. Oh my God. This is 130 pages. Oh my God, oh my God, oh my God. Okay, hold on. We need the other 2 aggravators, though. Where are they? So many court filings. oh my God, 64 pages, you guys. Wait. Are my eyes tricking me right now? Am I reading this? Oh my God. How has nobody said something about this on LawTube yet? Motion to strike the death penalty on grounds of state speedy trial preventing effective assistance of counsel. You guys, okay, I have to say, so I've followed this case from the very beginning, but I just started covering it a few months ago. But I'm up on all of it, right? I mean, I've not missed anything. And so this speedy trial thing was a huge deal for a long time. And there was a lot of gamesmanship around this speedy trial. And man, I'm trying to remember what was like, there was a whole thing about, because they had like a trial date set and it was like, is he going to waive speedy at last minute? And they were like, we're not going to waive speedy. And then sure enough, they like waived speedy, like pretty much last minute. I mean, not last minute, but like almost last minute. And, and that's when they started filing, like started working on like the change of venue stuff. But like, I'm trying to remember where all that ended up. This feels like such a long time ago, but like basically it was really clear. Oh my God. Judge might have a fucking field day. If I remember correctly, it was really clear that this is not a thing that's going to be talked about. Like and he made a thorough record and it's like he chose. I cannot believe I'm seeing this right now. But also where are the other aggravators? Why am I missing my other aggravators? There's the other disregard. Maybe. Hold on. Let me just make sure I didn't accidentally close. So hold on. There's supposed to be 5 aggravators. You know what I mean? So let's just make sure. Felony murder. Did we do felony murder? Future dangerousness. I don't think we have this one. Okay. Let's see. Yeah, we did not have. This was the one we were missing. Perfect. All right. We're going in order, not in the order of the tabs, but in the order of the things. So we have to finish our aggravating factors. Oh my God, this is 21 pages. You know, should I be like the only person on LawTube that reads literally all of these and all the pages? I mean, I think I read more of the memorandum about changing venue. That was like 316 pages. I think I read more of that than anybody did. Anywho, all right. So this is the 4th aggravator. So motion to strike future dangerousness aggravator. I have to say that's one of those things that I don't know that they can make that determination. I mean, that would have to be, well, that's where a forensic psychologist would be helpful. Let's see what they say. I don't know, because we don't know. You know, we might learn a lot here because because of the gag order, by the way, for anyone who doesn't know, there's been a gag order on this case, right? So we actually don't really know anything unless it comes out in the court filings or like in a hearing. We don't know. I mean, he's been assessed. I mean, we just don't know anything. And he's also done a good job of maintaining his 5th Amendment, right? He's not said a goddamn word. He's been, literally, he just is silent and not, I mean, he's just like he's doing all that. All right. Okay. So issues, fails to narrow the class, is irrelevant culpability and therefore cannot be an aggravator. Okay. Argument. The United States Supreme Court has stated that the 8th Amendment's prohibition against cruel and unusual punishment made applicable, blah, blah, prohibits the state from imposing the death penalty in an arbitrary and capricious manner. Right. Again, so I'm realizing they kind of all start with this same sentence, don't they? Instead, the sentencing body must be provided with standards for genuinely narrow. Again, this is like, I think it's like copied and paste maybe. Now I'm realizing that this is like the whole, which isn't a bad thing. Like that makes sense, right? Like here's the thing for when you're talking about this. Okay. Yep. Because I feel like we've read all of this. Yep, we have. Okay. Here we go. Now this is specific to this actual propensity or actual aggravator about propensity. We would construe propensity to exclude, for example, a person who has no inclination to kill, but in an episode of rage, such as during an emotional family or lover's quarrel, commits the offense of murder. We would doubt that most of those convicted of murder would again commit murder. and rather we construe, this is where we need a forensic psychologist, guys. We construe the propensity language to specify that that person who is a willing, predisposed killer, a killer who tends toward destroying the life of another, or who kills with less than the normal amount of provocation. I mean, again, but all that is so fucking vague. Just makes me want to rip my hair out. We would hold that propensity assumes a proclivity, a susceptibility, and even an affinity toward committing the act of murder. Okay, both holdings are problematic within the jurisprudence outlined above. First, the Idaho Supreme Court's definition of propensity to commit murder matches and even makes use of the language from the definition of murder. Essentially, the court excluded manslaughter. Second, the United States Supreme Court failed to recognize that the vagueness inherent in the question of whether a particular individual poses a threat to society is that the very factors that might lead one person to conclude that they should die may be thought of by another as a reason for mercy. It is not clear from the decades of authorities on the subject whether the homicidally inclined are to be despised or pitied. Wow, that's a sentence, isn't it? Finally, such evidence is not relevant to determining which defendants are culpable of acts worthy of the death penalty. So again, their first issue that they're taking here is that it fails to narrow down the class of death-eligible defendants. Okay, ready for this one, guys? Murder is defined in Idaho as, we are learning, the unlawful killing of a human being, including but not limited to a human embryo or fetus. So is abortion illegal in Idaho? I'm not going to even get into that right now because that's a whole other thing. We're already on the death penalty. Human embryo or fetus with malice, aforethought, or the intentional application of torture to a human being, which results in the death of a human being. Torture is the intentional infliction of extreme and prolonged pain with the intent to cause suffering. It shall also be torture to inflict on a human being extreme and prolonged acts of brutality, irrespective of proof of intent to cause suffering. The death of a human being caused by such torture is murder, irrespective of proof of specific intent to kill. Torture causing death shall be deemed the equivalent of intent to kill. Yeah, I bet you're glad you're in Canada, huh? The Supreme Court's interpretation of future dangerousness would clearly catch all torturers within its ambit. Ambit? Is that a word? I don't know. Is gambit? I don't know. So the only question is whether those who unlawfully kill with malice aforethought are meaningfully separated out, I think that's a typo, by the court's gloss. The legislature defines malice aforethought as, again, this is from Idaho Code. Such malice may be expressed or implied. It is expressed when there's manifested a deliberate intention. Ooh, using bold. That's they're making a statement, right? That's a big deal when they do that in court filings. Is manifested a deliberate intention unlawfully to take away the life of a fellow creature. Wait, doesn't that include like animals though? It is implied when no considerable provocation appears or when the circumstances attending the killing show an abandoned and malignant heart. Malignant heart? What the fuck? Dude, you guys. All right. I don't even know where to begin with that one. Okay. I have no idea what forced birthing is. And I don't know what you're confused about, Kat. Okay, so, and then, yeah, there's emphasis added. Yep, Purdue. This language corresponds almost exactly with that used, I should say used, not used, by the Supreme Court to define those with a preference. I've said it before and I say it again. Ann Taylor, Jay Logsdon, y'all, look, I will proofread these documents for you and correct the typos, spelling errors, what have you. I will do it. Just let me know. I'm doing it anyway, right? All right. Used by the Supreme Court to define those with propensity to kill. Okay, so this is propensity, right? We would construe propensity to exclude, for example, a person who has no inclination to kill, but in an episode of rage, stirring an emotional family or lover's quarrel. Oh, we've already seen something similar earlier. And rather we construe the propensity language to specify that a person who is willing to predispose killer, a killer who tends toward destroying the life of another. Okay, yeah, this was already included earlier. All right, these definitions are essentially the same. All right, yep. All right, and then we have inclination and propensity as defined by the Oxford American Dictionary means a person's natural tendency or urge to act or feel in a particular way. According to the New Oxford American Dictionary, affinity means a spontaneous or natural liking or sympathy for someone or something. To be willing is to be inclined to do something. To have a predisposition toward a thing is to have a liability or a tendency to hold a particular attitude or act in a particular way. The New Oxford American Dictionary defines susceptibility as the state or fact of being likely or liable to be influenced or harmed by a particular thing. Again, I'm correcting their typos as I go. It would be impossible for a person to be inclined to murder without being susceptible to the concept. To kill without inclination, propensity, or intent, but in a fit of rage, is traditionally understood to be manslaughter. Yep. Indeed, Idaho defines voluntary manslaughter as the unlawful killing of a human being, including but not limited to a human embryo or fetus without malice. It is of three kinds: voluntary, I guess they're not including the other two kinds. They're just showing the first, voluntary, upon a sudden quarrel or heat of passion, I guess. Okay. All right. They're also saying their next issue is that it's impermissibly vague. And again, we're talking about this future dangerousness aggravator, which is the same thing as propensity, right? Basically, it's essentially saying, would they kill again? But this is an aggravator for the death penalty here. Okay. The United States Supreme Court held that future dangerousness was not vague, as it was something judges had to do all the time. While this is true, the vagueness of future dangerousness does not lie in what the concept means, but what a jury is intended to do with the information, right? Because the jury is the one that's going to be determining this, right? Traditionally, future dangerousness was seen as mental illness, which in turn was seen as mitigating circumstance. Holy fuck, what a mind fuck that is. Okay, let me read that part again. All right, let's read that again. That's a mind fuck. All right. Traditionally, future dangerousness was seen as mental illness, which in turn was a mitigating circumstance. So what they're saying here is what used to be a mitigating circumstance, which is to say a reason against the death penalty, right? Because again, the mitigating factors go against the aggravators and the jury has to weigh those. So a mitigating circumstance. What used to be a mitigating circumstance is now an aggravator. That's insane to me. Wow, my brain. Wow. That's wild. The Supreme Court has confusingly also held to this traditional understanding in reversing death penalty cases is evidence of future dangerousness both an aggravating and a mitigating factor. Yeah, that's not possible. Oh my God, why? It can't be both. It can't be both. If it is, then how can this evidence be adequate to inform it? It can't be both. Adequate to inform jurors what they must find to impose the death penalty, and leaving it up to the jurors, of course. And as a result, leaves them and appellate courts with a kind of open-ended. You know what? I tell you what. You see just taking a look at like any snippet of any one of these documents, and you know what? It is clear why we hear about these death penalty appeals going on for decades, because it's wrought with issues, man. I mean, even beyond the issue of it being a thing, right? Even beyond any of that, like just this one thing alone, that like, it's clear that like the legislature needs to get it together or something, right? Like it's fraught with error. Everything we've read is like error after error after error. It's like, what? How is this even a thing? I mean, no wonder. Fuck. Good. I'm flabbergasted right now. I'm shocked. I am shocked. I'm shocked. Okay. Wow. At the founding, oh good, this has got to be Jay Logsdon again, because we're getting a touch of history. At the founding and throughout the 19th century, mental illness was a difficult issue for the judiciary. Theories about how the mind operated led many scholars to conclude that negative behaviors were symptoms of mental illness, and thus removed responsibility for all evil actions. In essence, since no rational being would behave badly, all criminals were madmen. Okay? While psychology has come a long way since the 19th century, the definition of mental disorder still contains the basic concept that a person choosing sustained negative behaviors is mentally ill. According to the DSM-V, a mental disorder is interesting. All right, we're getting a definition here from the DSM-V, guys. A mental disorder is a syndrome characterized by clinically significant disturbance in an individual's cognition, emotion regulation, or behavior that reflects a dysfunction in the psychological, biological, or developmental processes underlying mental functioning. Mental disorders are usually associated with significant distress or disability in social, occupational, or other important activities. An expectable or culturally approved response to a common stressor or loss, such as the death of a loved one, is not a mental disorder. Socially deviant behavior, such as political, religious, or sexual, and conflicts that are primarily between the individual and society are not mental disorders unless the deviance or conflicts results from a dysfunction in the individual as described above. And then citing DSM-V, practically speaking, every case where a jury is asked to find a person is likely. Oh, I see. Okay. Practically speaking, every case where a jury is asked to find a person is likely to pose a threat of future dangerousness will involve underlying significant disturbances in that person's mental functioning. I see what he's saying there. From the Supreme Court's view, a mental illness of a type that renders a person unable to understand the meaning of or reason for it bars the application of the death penalty. Right. That's like being, that's like the competency thing, right? Fit for trial and all that, like that whole thing. If you can assist in your own defense, that whole deal. All other forms of mental illness are mitigating, and only an ineffective attorney would not fully investigate and consider presenting such evidence to a jury. Case law there. In turn, legislatures have labeled this same evidence as aggravating. God, that's just what? I mean, my brain. By pointing out that the factors that reduce culpability are increasing the threat the defendant in question poses to society. Mother of God. There's nothing new about making this observation, but by placing the legislative weight on the aggravation side of the scale, the evidence considered constitutionally mitigating is rendered a danger to the capital defendant. Double-edged sword. Yes. Yep. The best response to this decision the Supreme Court has made is that though the legislature renders the evidence aggravating at the base of a death qualifying pyramid, the jury can still treat it as mitigating at the apex. What the fuck does that mean? Oh, why does it seem like exactly like what they would say, right? I mean, because it makes no fucking sense. All right, here we go. Oh my God. I see. That's the point. That's his point. Okay, let me read that again. That's his point. That's his point. He's like, okay. I mean, it's clear what they're doing here is there's like, this is all fucked. So let's not. Let's just get rid of this and call it a day. I mean, I don't blame them. This is a mess. Okay. So this is his point, is that the best response is a mess. Okay. The best response to this decision that the Supreme Court has made is that though the legislature renders the evidence aggravating at the base of death qualifying pyramid, the jury can still treat it as mitigating at the apex. That explanation of how the system is to work is made all the more Kafkaesque by states like Idaho that require defendants to give up rights and privileges in order to introduce evidence of a mental disorder. Oh my God. Oh my God. The system is not well served by permitting the legislature to make the purpose of psychological evidence unclear for juries. Studies have shown that juries are confused by the double intentions behind such evidence and typically find it aggravating, which is ironic in and of itself, right? Because we're talking about aggravating factors. I'm sure he did that on purpose to make Judge chuckle, because for anyone who doesn't know, this attorney, I'm sure, is Jay Logsdon, and him and Judge have like a history of back and forth with like loving this like exercise of like motions practice, and it's really kind of funny. And I think my guess is that he wrote this because he knew it would make Judge chuckle. That's my guess. We'll find out. We might find out when they have a hearing on it, but that's my guess. because I thought that was that, because that made me chuckle, like in my heart. Okay, so therefore, for the clarity of the jury, the future dangerousness aggravator should be struck in this matter. Okay. And then they're also saying it's the same that here, all of that is just citing back to, again, this whole thing of future dangerousness is irrelevant to culpability and thus cannot be an aggravator. Basically, that makes sense logically, right? Because it's propensity. It's saying that you would do it again, but you haven't been convicted, like it's not even been determined that you've done it in the first place, right? So it makes sense. It's like putting the cart before the horse or the chicken before the egg or whatever it is, right? So that makes sense. More concerning from a constitutional standpoint is that the United States Supreme Court has never actually held that evidence of future dangerousness is relevant to whether someone should die. The Eighth Amendment requires that defendants only be condemned to death if they are deserving of the ultimate punishment based on their culpability, not their dangerousness. Then why are we here, man? How is this happening? Okay. You know, I'm telling you guys, it's like this stuff just makes me want to just quit everything and go and become like a defense attorney and try to save people's lives. That's all. Okay, let's keep going. So the Supreme Court held, this is from 1983, closely related to yet distinct from respondents' speculativeness argument is the contention that the Briggs I'm not going to read. Oh, look, we're trying. I'm not going to read all this. This is long and whatever. Okay, let's just keep going. It's old case law. Anyhow, they're talking about that pyramid analogy that made no sense. All right, conclusion. Based upon well, then what's the rest of this? It's got more pages. What's on the other pages? There's it's J. Logston again. Oh, we have an exhibit. What? Overview of task force proposal on mental disability and the death penalty. Oh, this is what okay, these are the things they were citing, I guess. They're including it. Okay, I got it. Yeah. All right, cool. Okay. And we're done with another one. We have, I think, one more to go, right? Utter disregard. What the fuck is this? Let's find out together. This is the fifth out of the five. There are 5 aggravators. This is the last one, number 5. Okay. Again, I'm realizing this is all just copied and pasted for the beginning part of all of these. All right. The utter disregard for human life as an aggravator appears to be an Idaho invention. Wow. Though the phrase first appeared in 1888 in Missouri in a manslaughter case. It appears thereafter in various states as a formulation of gross negligence amounting to wantonness, the mens rea for murder as opposed to manslaughter, and the mens rea for second-degree murder where the intent to kill is lacking. In Idaho, the language utter disregard for the safety of others began being used regularly in tort cases involving car accidents. That makes sense, definitely. Yep, that sounds like a negligence thing to me. Yeah, and so I see where he's going with this. Utter disregard for the safety of others, like negligence in a car accident, right? I see where he's going with this, because how the fuck is this an aggravator for the death penalty? Like, you gotta be kidding me. What is happening right now? I'm already mad. Like, oh my God. Okay, all right, keep reading. It then appeared as a description of the mens rea for manslaughter. So he's saying over time, it went from being like used in car accident civil cases, and over time it's developing, right? So it goes from that, Jesus Christ. Now it then appeared as a description of the mens rea for manslaughter, quoting a decision from the Illinois Supreme Court. After that, this is disgusting. After that, the phrase utter disregard for the safety of others became a formulation of criminal negligence used in jury instructions. However, the phrase still appeared infrequently at best. I don't even know. Idaho's highest court has placed a judicial gloss on the statute such that the state must show acts or circumstances surrounding the crime that exhibit the utmost callous disregard for human life, i.e. the cold-blooded, pitiless slayer. Cold-blooded means marked by an absence of warm feeling. Without, this is what Idaho's saying, okay? Without consideration, compunction, or clemency, matter of fact, or emotionless. Pitiless means devoid of or unmoved by mercy or compassion. A cold-blooded, pitiless slayer refers to a slayer who kills without feeling or sympathy. The utter disregard factor refers to the defendant's lack of conscience regarding killing another human being. Other jurisdictions. The other disregard aggravator exists in no other state. Oh, man. However, the basic concept can be found elsewhere. Problematically for this court, it turns up largely as a way of defining the almost ubiquitous heinous, atrocious, or cruel aggravator, here and after the HAC, as we've already read that one. Missouri, for example, defines its HAC aggravator as a killing that shows callous disregard for human life. So it's redundant is, I think, the point here, right? Argument. This court should strike the utter disregard aggravator in this matter. First, the court should find that the gloss placed on the aggravator by the Idaho Supreme Court was in violation of the Idaho Constitution. Without this gloss, the wording of the aggravator has already been deemed unconstitutional by Idaho and the United States Supreme Courts. Additionally, the saving construction does not actually appear for the aggravator. And then separation of powers. And when they're talking about separation of powers, they're talking about the judicial branch versus the legislative branch, right? Because sometimes things happen through case law, right? And it sets a precedent. Other times it's done through the legislature, right? Okay, now we're going to learn what the actual definition. I love it. I love these definitions, though. All right. So the utter means complete, absolute. Disregard means the action or state of ignoring something. Going through other definitions. Conclusion. We know what they're going to say. Get rid of it. I have utter disregard for the utter disregard aggravator. I mean, right? It's insanity. Literally, it's insanity. Dude, you're gonna have to go back after this live stream or whenever, right? And watch the other parts that I've read about, because the amount, there's actually a part where I was saying something was like arbitrary and like subjective, and I was like losing my mind. And then I read for another minute or two, and then literally in the filing, they actually called it the same thing. They called it arbitrary, and I was like, oh my God, like it's insane. Like the amount of like subjectiveness and vagueness and just like what was it that I said earlier? I was like, one person's horrible is another person's cup of tea, because they use the word horrible. Like in one of the aggravators, they actually use the word horrible. It has to be horrible. I don't remember which one it was, and I already closed out the tab, but one of the things was it has to be horrible. Horrible. And the jury has to make these decisions to weigh the death penalty, because they're the ones who decide it. And that's when I told the story about accidentally pouring orange juice on my cereal, and I said it was horrible. I mean, okay. Bye-bye to that one. I am really curious about this speedy trial situation, because what are they going to say here? This is insane. Motion to strike the death penalty on grounds of state speedy trial preventing effectiveness counsel. Judge, I'm curious. I feel like he's going to have a field day with this. Because I mean, he waived his right to a speedy trial, and that was the whole thing. Okay. All right, issues. Idaho requires all criminal defendants to be brought to trial in 6 months from the arraignment on an indictment pursuant to statute and its constitution. In Idaho, the right to a speedy trial is defined by IC blah blah, as it was at the time of the adoption of the Constitution. The Idaho Constitution guarantees a speedy trial except where there is a good cause for delay, or the request for postponement came from the defendant, which is what happened here. Okay. The Idaho Constitution requires a fixed amount of time to constitute undue delay. This court should adopt the 6-month line adopted by our legislature. A defendant in Idaho can never request additional time without losing his right to speedy trial. A capital case cannot be prepared in 10 months. Idaho cannot force a defendant to choose between his rights. Procedural history. So this is actually, okay. This is actually refreshing. Remember when I was like, oh, I'm trying to remember what all was going on with the speed trial. Well, here we go. Excellent. So he was arrested, his first appearance, blah, 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 blah. Okay. Let's get to the part closer in time. Okay, here we go. On May 23rd, 2023, pursuant to Mr. Kohberger's right to a speedy trial, this court set Mr. Kohberger's jury trial for October 2nd, 2023. A mere 10 months from his arrest. Again, because why? Because, where is it? Oh, that says it can't be prepared in 10 months. Well, I don't know. I was going to say because it's 10 months, but I guess that's the minimum. On August 23rd, 2023, Mr. Kohberger waived his right to a speedy trial in order to secure his right to effective assistance of counsel. No, Judge Judd's going to lose his mind. Literally, he was like, you can't say you're doing it for that reason. Attorneys, like literally, y'all, I can't believe I'm reading this right now. Like literally, they all had to like be like, yep, we know this isn't the case. We can't make this argument, but yeah, here they go. I mean, zealous advocacy at its finest though, right? Man. Because like, they always say, if you're not getting yelled, what's the saying? It's like, if you're not getting yelled at, you're not doing your job as a defense attorney. Like you're supposed to be, like your job as a defense attorney is to be like pushing the limits because otherwise rights would be trampled. So like, I think Runkle said something like, what was it? I don't know. I'm trying to remember. It's just like part of it, right? If you're not getting yelled at, you're not doing your job, they say. So, argument. Idaho requires all criminal defense to be brought to trial in 6 months from the arraignment on an indictment, blah, blah, blah. Unless good cause to the contrary is shown, if a defendant in whose trial has not been postponed upon his application is not brought to trial within 6 months, from that date, the information is filed with the court. So we know all this. It's their rights to speedy trial. We know all this. Case law. Blah, blah, blah. I cannot believe that they're even doing this. I mean, I guess I can, but I also can't. Like, I guess it's like, I shouldn't be surprised at this point because they're pulling out all the stops to save his life, as they should. But I'm just still surprised because I'm like, wait a second. I thought this issue was put to bed a long time ago. Oh my God, we're going back to Idaho territory. Sweet. The framers were back to the framers and what the framers meant. Oh boy. This court may require some explanation. Yes. This court may require some explanation for what may seem a vague directive that terms now only used by our Supreme Court were to be held until there was nothing left to do or the judge needed to be elsewhere. In the days of the territories of our country, it was unnecessary to employ vast numbers of district judges, as the cases appropriate for them, as defined in Idaho in the good year 1887, were typically few. In the Idaho territory, 3 judges handled all of the work of the district courts and the Supreme Court. Each of the 3 sat as a district judge, and they sat together as the Supreme Court. They exercised the jurisdiction of local or territorial courts and of federal courts. So 3 judges for the entire state to do it all. That is wild. That's mind-boggling. For state and federal and local. All the jurisdictions, all of the venues. What is happening? That is insane. Okay. So the judge put it in Michigan in 1828. I'm not going to read all that. Wow. When the Constitution was adopted, there was a lot of debate over whether to add additional judges. How was there debate? It sounds like you need more than 3. A vocal part of the delegation led by William McConnell of Latah, look at that, argued that adding 5 additional judges to act solely as district judges was too much expense. Oh my God. Oh my God. When Weldon Hayburn of Shoshone and the judges argued that all courts were months and months behind, boy, it's just gotten worse ever since, right? It's like that's how it started. And then those were the good old days when it was just months behind, right? McConnell's faction argued it was the lawyers who were to blame. This is wild. Judges versus lawyers, who's to blame? In the end, it was the geography of our state that was to decide the issue. The delegation overwhelmingly supported 5 new districts and judges. They rejected thereby a compromise of 4 districts, placing 2 judges in North Idaho and 2 in the South as clearly unfair to the South, where some would have to travel 1,200 miles to get to court. How long would it take them? They would have to go by what, horseback? I can't even, you guys. What would that take? Like a year? I don't even. Let me read that again. Clearly unfair to the South, where some would have to travel 1,200 miles to get to court. I'm dying. So that's why they said that they ended up blaming the geography of the state for the backlog. Oh my God, y'all. Whew. Okay. The delegation clearly agreed with Judge Morgan. Shout out to Judge Morgan, who said, quote, "It is ruinous, absolutely ruinous, to men to have cases for trial in these courts because the subject of litigation becomes worthless after such a long time, or because they have great amounts of money invested." Oh my God. The upshot was Article 5, Section 11, which states, "The state shall be divided into 5 judicial districts, for each of which a judge shall be chosen by the qualified electors thereof, whose term of office shall be 4 years. And there shall be held a district court in each county at least twice in each year to continue for such time in each county as may be prescribed by law. But the legislature may reduce or increase the number of districts, district judges, and district attorneys. This section shall not be construed to prevent the holding of special terms under such regulations as may be provided by law." The court should note that in the Constitution, though the district judges were provided some leeway over when court would be held in various counties, that had to occur at least twice each year. Twice each year? What? 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 Okay. Additionally, the legislature had and has the power to require special terms. Okay, let's keep going. Okay, the Idaho Constitution guarantees a speedy trial except where there is good cause for delay. Or right. We know that. We're all good there. Okay, the 6-month line. Righto. I'm curious about the 10-month thing when they get there. Aha. Oh, excellent. Now we're going to go back to England common law. Sweet. All right. The court then reviewed the history of the right to a jury trial in the common law of England, other jurisdictions, and in Idaho at the time of statehood. The court found, quote, "At the time of statehood, the territory of Idaho made 2 specific exceptions to an otherwise all-encompassing grant of the right to jury trial in criminal actions," end quote. The court then looked to the framers, shout out the framers, and the Constitution itself for meaning. The court found that the framers had imprisonment and punitive measures in mind. The court determined that this history permitted summary proceedings if the sanction is decriminalized. Here, as argued above, the history of terms of court at the time of the adoption of our Constitution would permit this court to find that the framers did not wish for people to languish in jail awaiting trial. They didn't want the people to languish. The courts were not to have fewer than 2 terms, meaning that stretching those terms to their limits, a person could have sat for more than a year. Oh, that's how they get to 6 months. That makes sense, right? Okay, that makes sense because of the 2 terms. 2 terms per year. They court twice a year. Incredible, but that's how they got the 6 months. Wow, that's where it came from. That's where we got 6 months for a speedy trial. Holy mackerel! Wow, you learn something new every day. We've learned a lot new today. Actually, we learned like enough for a year today. I feel like. Wow, incredible. Okay, so. Since 1975, no defendant needs to worry that a judge will become unavailable, leaving them detained essentially incommunicado. All the same, the weight of imprisonment and awaiting trial cannot be made much easier by having a judge available who does not hear your case, though you ask it more heard to. To some extent, the feeling of begging for one's freedom and having it fall on deaf ears as time drags on might be worse. This is the one I was really especially interested in because of the fact that they said it was set for 10 months, 10 months from the date of the indictment. So, okay, BRB. I'm just going to grab some more water because I've so much talking, so much water drinking. Hold on. Okay, I'm back. All right. Capital case cannot be prepared in 10 months. With the 6 months to trial as a backdrop, modern death penalty work becomes impossible. Undersigned counsel is unable to fulfill the requirements of the ABA guidelines for the appointment and performance of defense counsel in death penalty proceedings and the supplementary guidelines for mitigation function of defense teams in death penalty cases, which have been blah, 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 blah. That's a really long sentence with just case law. All right. Death penalty cases must be considered differently compared to non-death penalty cases. They must be subjected to heightened constitutional scrutiny. Put simply, so long as Mr. Kohberger's execution is a possible result in this case, the state of Idaho must take basic, if not extraordinary, measures to protect his constitutional rights. Yep. This is abundantly clear from the 6th and 14th Amendments and is enunciated precisely in the case of HAC v. Oklahoma. I'm not going to read all that. Unquestionably, the prosecution's intent to seek the death penalty ratchets up the demands on defense counsel. I love his imagination, Jay Logston. It's got just just a really great imagination when it comes to, the language he uses in his motions. Now, where are these demands more clearly? Oh, sorry, I can't read. Nowhere. Nowhere are these demands more clearly enunciated than in the ABA guidelines for the appointment and performance of defense counsel in death penalty proceedings. Defense counsel incurs the immediate obligation to conduct a thorough investigation at every stage of this case, and this duty is intensified, as are many duties, by the unique nature of the death penalty. As has been emphasized by recent statutory changes, it is broadened by the bifurcation of capital trials, right? And then, of course, at this point, we now know that they're hoping to have it trifurcated, and it certainly should be, in my opinion. The breadth and scope, okay, blah, 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 blah. All right, the duty to investigate, let me see. Okay, so now they're just talking about how much stuff they have to do, which we know. I'm sure that it's an incredible amount of work, obviously. Just the starting point. Okay, let's take a look at this. Just the starting point for defense counsel includes medical history, including hospitalizations, mental and physical illness or injury, alcohol and drug use, prenatal and birth trauma, malnutrition, developmental delays, and neurological damage. 2, family and social history, including physical, sexual, or emotional abuse, family history of mental illness, cognitive impairments, substance abuse, domestic violence, poverty, familial instability, neighborhood environment, and peer influence, other traumatic events such as exposure to criminal violence, loss of a loved one, or a natural disaster, experiences of racism or other social or ethnic bias, cultural or religious influences, failures of government or social intervention, such as the failure to intervene or provide necessary services, placement in poor quality foster care or juvenile detention facilities. 3, educational history, including achievement, performance, behavior, and activities, special educational needs, including cognitive limitations, learning disabilities, and opportunity or lack thereof, and activities. 4, military service, including length and type of service, conduct, special training, combat exposure, health, and mental services. 5, employment and training history, including skills and performance, and barriers to employability. And 6, prior juvenile and adult correctional experience, including conduct while under supervision in institutions of education or training and regarding clinical service. I have to say, it's wild that, I was going to say as far as we know, but I'm pretty sure it's not even an unknown, like that this defendant, Bryan Kohberger, this is his first charge, which is insane, right? Think about it, right? I don't think he's, I mean, maybe I feel like, did he even ever have a speeding ticket? I don't think so. Again, that seems like normal for him to have a speeding ticket, but basically, isn't it wild though to think that the first thing you ever get charged with a crime and it's a quadruple homicide? It's insane, right? I mean, that's not normal, right? The fact that most people would work their way up to that, know what I mean? That's a hell of a place to start though. And to be able to carry that out in less than 16 minutes is insanity with a knife. Okay. So none of this material is necessarily easy to procure. His most personal experiences, quote, may be extremely difficult for the client to discuss. Indeed, defense counsel must build a special rapport with his client for all proceedings. He's asking the client to trust counsel with his life, in italics. And even the information defense counsel can collect then requires the collection of corroborating information. Yep. This is not the type of investigation that can wait until the week or even the month before trial. Well, obviously, we know that. To the contrary, the very possibility of the penalty phase proceedings weighs heavily. Of course it does. God, I hate that for them. On defense counsel's preparations from the moment they begin to work on the case. Yep. And then here's, this is actually from, again, what they have to follow, the American Bar Association guidelines. Quote, the mitigation investigation should begin as quickly as possible because it may affect the investigation of the first phase defenses, decisions about the need for expert evaluations, motion practice, and plea negotiations. The penalty phase is in that sense a misnomer. For the defendant, the penalty phase begins as soon as the possibility of a death sentence arises, whether or not he has yet been found guilty. Yep, I hate this. This is depressing. The mitigation investigation, furthermore, runs in parallel with many tasks of defense counsel to prevent or prepare for trial on the original charges. Yeah, and that's something we heard a lot about from Ann Taylor in when they were talking, before in different hearings, where it's they can't prepare for both at the same time because it's two completely different things. It's nothing that they do in preparing for the regular trial, right? The guilt phase, if you will. None of that. There's no overlap. It's completely separate, right? And that's if it's bifurcated. Now, we know from the part I read earlier at the beginning of the stream that they're making a motion to have it trifurcated to make it 3 sections, as it clearly, I learned it should be done. Anyway, but it's a lot. It's a fucking lot, I have to say. Okay, so yeah, the mitigation furthermore runs parallel, right? It is no surprise then that one study estimates that the average capital trial consumes nearly 1,900 hours of defense counsel's time, over 16 times the average hours spent on non-capital homicide cases. Wow. 16 times the number of hours. That estimate itself is not an indictment of the capital punishment system. It reflects in part the extraordinary measures required to ensure a fair hearing for a defendant accused of a capital crime. However, the demands on capital counsel become a constitutional problem when, as in Idaho, the state's speedy trial requirement hamstrings defense counsel's ability to commit the requisite time. So I see what's happening here is that it seems like they're saying that 10 months isn't long enough. It's kind of like taking issue with, I guess, really that precedent. I think they said it was actually in the legislature, though, didn't they? Is this going to be one of those things where Jay Logsdon is trying to change something that it can only be changed by the legislative branch? Because I think that might be what's happening here. And he's going to try. We've seen it before. So as far as that goes, though, initially before the gag order, when he was first arrested and stuff, there was quite a bit known about him. And I know you're kind of new to the case, CC, but there was quite a bit known about him. For example, he was a criminal justice major, and he actually studied and was mentored by Dr. Ramsland, who's like an author and a renowned forensic psychologist who's like really famous and writes books and is like BFF with BTK killer, Dennis Rader. Like she studies serial killers. She was like his mentor and stuff. Like there's stuff that's known like that. Like, he came out to Washington to go to University of Washington, which is like 10 minutes away from Moscow, Idaho. And he apparently also had applied to work at the police station or whatever there. And they didn't hire him. He wanted to I guess be their IT guy. So, and you know what? The peeping bit is part of my PowerPoint presentation that I keep referencing because the voyeurism is a big part of this case, I think. In my opinion, that's how he was able to get in and out so quickly and in the dark because he was very familiar with that house. It's entirely possible. Actually, this is not my opinion. This is the opinion of experts who are very well respected in terms of their psychologists and detectives and stuff. But they, I use them a lot to formulate that PowerPoint presentation. Anyway, they're kind of the opinion that he probably had been in that house before. And then we know it was like a party house. It was left unlocked a lot of the time. People came in and out. I mean, but it's possible. Anyway, okay. So, but it was still crazy though that having not actually been convicted of convicted of a crime or anything. Okay, so the state, with its one hand, can dramatically escalate the demands on Mr. Kohberger and defense counsel by noticing intent to seek death. Yet with its other hand, it rigs the system so that it can be assured that defense counsel cannot meet those demands or must counsel a client to give up his right. So I see what he's saying. I mean, it's true that this whole speedy trial thing, I didn't really know it until this case, because this is where you really got to see front and center how the speedy trial is sad, right? This is somebody's rights, but the speedy trial is used as a bargaining chip. It's a strategy thing. It was kind of gross, to be honest with you. But it shouldn't have to be doing that in the first place, right? But this makes sense what they're saying here, which is that there's a lot of strategy from the prosecution, and essentially no matter what, even no matter how strategic and clever the defense attorneys can be, it still all boiled down to this choice that they have to make, which is giving up their right to speedy trial or, not being able to have proper a proper defense. And that's exactly what happened. I mean, literally, it brings this but listen to how this is written, though. This is right. Shout out to Jay Logston, man. I'm going to read it again. The state with its one hand can dramatically escalate the demands on Mr. Kohberger and defense counsel by noticing intent to seek death. Yet with its other hand, it rigs the system so that it can be assured that defense counsel cannot meet those demands or must counsel a client to give up his right to speedy trial. 3, Idaho cannot force a defendant to choose between his rights. I'm going to take a sip of water. Okay. The hallmark, okay. This is U.S. Supreme Court case law from 1984. There are circumstances that are so likely to prejudice the accused that the cost of litigating their effect in a particular case is unjustified. Oh, fuck. Let me read that again. There are circumstances that are so likely to prejudice the accused that the cost of litigating their effect in a particular case is unjustified. Is that saying it's not worth hire? Hold on. I don't know yet what that means. Let's keep reading. The hallmark of such situations is that, quote, although counsel is available to assist the accused during trial, the likelihood that any lawyer, even a fully competent one, could provide effective assistance is so small that a presumption of prejudice is appropriate without inquiry into the actual conduct of the trial. What the fuck? They're like saying, why bother? Because there's no way anyone could possibly do this task in the amount of time. Is that what they're saying? I'm so confused. Although counsel is available to assist the accused during trial, the likelihood that any lawyer, even a fully competent one, could provide effective assistance is so small that a presumption of prejudice is appropriate without inquiry into the actual conduct of the trial. In such cases, the defendant has been constructively denied his right to counsel and need not wait to assert his claim. Oh, I see. Okay. I see what they're saying. Okay. For example, ineffective assistance of counsel claims based on allegations that the attorney is faced with a conflict of interest are routinely. Okay. I see what they're saying. Yeah. They're saying that, okay, he's laying the groundwork, I believe, to try to say that this needs to be dealt now and not as an appellate issue. That's the point. That's where he's going with this, because it has to be done before trial. This is smart. They're trying to say, okay, look, we were hamstringed. His right to speedy trial is violated, and this needs to be handled now because of case law instead of waiting for this to be an appellate issue. That's smart. I mean, I don't think this is going to go anywhere, but as we know, you don't want to be doing things on appeal when he's on death row, if that happens, right? So, I mean, I will say, let me just say this real quick as an example, because again, this is Idaho. So Lori Vallow Daybell, in case anyone isn't familiar, that was an Idaho case, right? Lady, death penalty case. Just, recently, what was it? 2022. I watched the whole trial or listened because they didn't have cameras, but anyway, 2023. Yeah. So anyway, but that was a death penalty case, and she had court-appointed counsel, just like Bryan Kohberger. She didn't get nearly as lucky as he did with her counsel, but anyway. But what they did for her that was great was this. Due to, and this was kind of last minute, almost like right before the trial, there was a discovery violation from the prosecution. Okay. That discovery violation got that death penalty taken off the table. They saved her life. They saved her fucking life. Now, she still could be facing the death penalty in other states. But anyway, but that discovery violation was enough that they got that death penalty taken right off the table. Okay. So that's part of what I'm wondering, right? This whole, I'm trying to, read the tea leaves, as I say, this whole, this needs to be dealt with before trial. What can they do? Right? I don't think they're going to be asking to push the date out further. That's already happened. That ship has sailed. I don't think they're trying to ask for more time. If I had to guess where this is going, it's going to be in trying to lay the groundwork for saying this needs to be dealt with now, and it needs to be dealt with by taking the death penalty off the table. And that would also make sense because this is being filed in a slew of motions, and all of them have to do with the death penalty. So, and just again, using that as an example from Lori Vallow, same state. If Judge Judge finds anything in terms of there was some issue with where his rights were infringed, whether it's discovery violation, but or whatever, any of this, all it takes is for one little thing, and then that'll happen. That'll get taken off the table. They'll be successful here. So, okay, glad you guys are still listening. So, so this could, I hope it for them, I hope it for them. I hope it for everybody. I hope that, anyway. And again, I will say, for no matter where people stand in terms of the death penalty, because I know that's there's people feel very strongly. You have to say, his defense attorneys doing this, their job to the nth degree in the best way. Like, again, this is them trying to save his life. All these filings, like, it's holding. You have to understand that what that does for the rest of us here in the country is it should give us hope, right? Because the prosecution has to do better. When you've got defense attorneys like this, the state can't get away with anything because the defense attorneys will find it. They will find it and they will get this case thrown out. You know what I mean? So, like, it makes everyone have to do better. I mean, I'm not going to start going on and on about how important defense attorneys are because that you guys know I could do that all day, but that's just one thing. All right. State courts have applied this wisdom to conflicts created by resource shortages. When states have failed to provide adequate funding to public defenders, courts have recognized this results in a, quote, conflict of interest is inevitably created when a public defender's excessive caseload forces him or her to choose between the rights of various indigent criminals he represents. Here, the choice of the prosecution to seek the death penalty in conjunction with the requirements for defense in a capital case, as required by Idaho, essentially forced Mr. Kohberger to abandon his right to speedy trial. I mean, essentially forced, that's accurate, but it didn't force. It essentially forced. So I don't know, we'll see. Courts in Idaho have long recognized that forcing citizens to choose between their rights is the same as depriving them of those rights. Well, okay. Hobson's choice. When the choice between testifying and giving up a benefit, well, that's different, right? The state of Idaho may not force this Hobson's choice on Mr. Kohberger, however, it did. And now the court has a waiver of a right based upon it. Waiver, however, must be voluntary. Oh, I see what they're saying. I see what they're saying. Right, because they're saying, because the thing is, like, he waived speedy, but they're arguing he didn't. I see. Okay. Remember when I first saw this and I was like, wait a second, what's happening? Because he waived speedy, right? And I'm like, how are they going to make this argument? Okay, I see. They're saying that he didn't really waive speedy because he didn't have a choice if he wanted to have any type of adequate counsel. I see. Okay, right. Yeah, that makes sense. I don't know. We'll see what happens. Thus, this situation has created an undeniable tension within this case. Ooh, tension. Without question, the surest. You guys. Did I predict the future or what? You guys heard it here first. Let me read this sentence. You guys, I did. Squirrely crystal ball strikes again. What did I say? What did I say they're going to be doing? I said they're going to lay the framework to try to get that death penalty thrown out. Here we go. Squirrely crystal ball. Without question, the surest way to safeguard Mr. Kohberger's rights is to strike the death penalty and restore his right to speedy trial. There it is. Striking the death penalty will balance Mr. Kohberger's right to, I knew it, right to effective assistance of counsel with his right to speedy trial. Yep, or do. Yep. Furthermore, a death penalty structure that violates the Constitution is by its nature unconstitutional. Idaho's system of obtaining death convictions is unconstitutional at this time. This was recently recognized, and oh my God, again, squirrely crystal ball again, double one, State v. Vallow. That's Lori Vallow. Like, just in case anyone's not up, that's the case I was just talking about, where they threw out the death penalty because of the discovery violation. I can't believe that's even cited in here. I said it first. This is insane. Yeah, I know, right? It's, yeah. The notion of what is it? Kill people who kill people to show them that killing people is wrong. Again, circular reasoning. Not a fan of it. I can't believe this is in here. Wow. This was recently recognized in State v. Vallow, Fremont County case. Yep, Purdue. In this matter, it was recognized that within the time limits required for speedy trial, neither the state nor the defense could. Well, I thought it was a discovery violation, but it could be that this discovery violation is the reason why the speedy trial was violated. That would make sense. And there's a YouTube link or an East Idaho News link. Shout out to Oh my God, why am I blanking on his name? Shout out to Nate Eaton. Shout out to Nate Eaton of East Idaho News. All right. Conclusion. Based upon the foregoing argument to be presented at the hearing hereon, I can't wait for this hearing. I know I've already said that a million times, but this court is respectfully requested to grant this motion that they, get rid of it. No more death penalty. All right. Doo-doo-doom, boom, boom. Another one bites the dust. Doo-doo-doom, boom, boom. Another one bites the dust, and another one's gone. Another one bites the dust. Doo-doo-doom. Okay, so we are making our merry way through these documents here. They've got an entire fucking 64-page document on the arbitrariness. I don't even know if I can stomach this because I've already seen enough of so much of the arbitrariness. Yeah, CC, I have to say, so I will just tell you real quick, this is a funny thing. So, just as an example, so like, whenever I have people that are like from other countries or like they're going to come to the US or like whatever, or even if it's just people in the US that are like going to travel, I'm like, I tell everybody, the first thing I tell, I'm not even joking. I tell everybody, don't go to Idaho and don't go to Wisconsin. Don't go there. Don't go there. Don't go there. There's some other states where crazy shit goes down, but I feel like the ratio of crazy shit to number of people that live there, that ratio is too high in my mind in Idaho and Wisconsin. I'm not even joking. Even my students, my violin students, like if they're like going, so I'm like, don't go to Idaho and don't go to Wisconsin. For the love of God. Who is which lawyer? I don't know who you're talking about. Okay, so what do we have left? We have this one. We have, I'm sure this is this is 143 pages, and I'm sure it's really good. Motion to strike. Let's see, is part of this exhibits? It is exhibits. Okay, so it's actually not that long then. That's what I was looking at. What's this one? On grounds of contemporary standards of decency. Well, I agree with that. Yep. These are all motions to strike the death penalty. Wow. Wow. 130 pages, 143 pages, 64 pages. Wow. I think what I might do is save these for next time. Unless y'all want to keep going. Yes. Okay, I see what you're saying. Yeah, he's got 3, and they probably have paralegals. Yeah. So he's got Ann Taylor's the lead, and then there's Alyssa Masoff. I think it's Masosoth, Alyssa Masoff, and then Jay Logston. Yeah. I think Idaho might be right below UCC. Please be safe. They're doing an excellent job. Really, it's and public defender. It's moving to me. Because they're fighting harder for him than anybody I've ever seen that you could pay for. Like, you couldn't buy this. Like, this is it's incredible, right? Oh no, Cece, what are you gonna do? Oh my God. Oh, that's awful. Well, you could go to this trial, maybe. How far are you from Latah/Ada County, depending on if they get that motion to change venue granted? Actually, in my intro, let me pull this up real quick, because I've got a map on here somewhere. Hold on. There we go. Let me pause it right here. See geography. So yeah, I mean, Moscow. So if they stay in Latah, I think that's closer to Canada, right? And then if they go to Ada, that's like where Boise is, that star, if it gets granted. Yeah, 100%. Yeah, so again, where BK, Bryan Kohberger, was going to school was in right there, like right basically on the border, essentially, of Idaho and Washington, just 10 minutes. So like you could go between University of Washington and the University of Idaho. It's like 10 minutes between the two, apparently. You know what's so crazy though? Like it surprises me every time when I see, like, I have no idea Idaho looks like. Let me find the picture. That, like, what? Does Canada look like that? I feel like, I mean, I guess in certain places maybe. I don't know. It just surprises me. I just didn't expect that for some reason. For Idaho. And you know what? I'm going to enjoy the pictures because guess what? I'm never going there. Stay far away. Oh, that's right. Yeah, it's interesting. I saw that you noticed that. I just saw that in the chat earlier. But that's interesting. Okay, so that's like is that like a local TV thing? I didn't really know, but I guess that's what that means. Interesting. Like a local TV station. So you might know some of the coverage in terms of that we've just learned so much about, right? The media exposure. You might actually have a firsthand account of like kind of what that is. I'm just looking to see if there's anything else interesting on here. There's the house. Yeah, we've looked at all this though. So, oh, the Rocky Mountains. Okay. Are you seeing dogs again? You know why? Because you're a cat. That makes sense. Have you guys seen this yet? By the way, so there was, I can't remember if y'all were here. There was a new Ezra episode yesterday that was spur of the moment because I've been having the StreamYard issues. And so it wasn't really planned. I just kind of did it to see if it would work, and then it worked. So I did it. But I have this new friend. It's Ezra. It's Ezra's new profile picture. The Sharkweasel. Custom hipster glasses and all. By the way, in the Discord, it's also an emoji. I figured the shark weasel was appropriate because, you know, Alex Murdoch is like the shrimp weasel. So this is the shark weasel with the mocha. If you guys knew how much time it took me to get those, I guess you call them the arms of the glasses. You guys knew how long I spent trying to get those to be the right angle to fit the weasel ears. You would think I'm insane, like certifiably insane. But it was really important. I was like, they have to be correct. They have to fit over the weasel ears correctly, and they have to look. And they're the actual ones. Like these are real glasses. Okay. I had to take the actual arms of the glasses and cut them off, right? And then like resize them and then like do all this and then like angle them and do all this. So they're the actual ones that came with those glasses. It's just custom for the weasel. Yeah, it's an antique cup, right? Because, you know, Ezra in her antique cup. I wish I knew how to put a sweater on it, but I don't know how I would do that. I mean, that would take some real skill. I mean, I would have to hire like a graphic design person to do that, probably. Although I'm really happy with how I was able to end up blending a little bit, because it used to be there was a harsher line between the shark and the weasel. But I was able to kind of like blend it in a little bit better there. So, you know, I don't know if that makes it more or less funny, but it makes it maybe look more, I don't know. It's blended. That's all I will say. where did I get the shark? It's just like a free image, it's just online, like an image. What do you mean, where did I get the shark? Like, I didn't take that picture with a camera, if that's what you're asking. Oh, is it really? You want to try to put a sweater on it? Oh, thank you. Cat says the neck hair to jaw looking good. Thank you. Yeah. Try to blend it in a little bit. Yeah, just in case anyone's confused, I didn't go out and find a shark and find a weasel and take pictures of them with a camera and then glue them together. I mean, probably a year ago, that would have been how I would have tried to do it. But see, I've learned how to do things since then from doing YouTube and making thumbnails. They've come a long way. And actually, some of you guys have probably heard this, I really love making the thumbnails. It's actually really fun. So I just use I use Adobe, and it makes it really easy to do stuff. So yeah, but I think I will save the rest of these documents for next time, because that was a lot of reading. And also, again, I'm thinking there might be more coming out in addition to this. And again, my squirrely crystal ball has been on point tonight, like on another level. So I may as well go out on a limb and say, I wonder if we might hear something from Judge tomorrow with a decision about the motion to change venue. So in that case, then I would love to be able to cover that with the rest of these. But yes, where I was going with all that is that tomorrow we also have another Ezra episode. But yes, there was an episode last night. That's what I was saying. We had the episode last night. So for anyone that missed it, that's time stamped. And then we'll have another one tomorrow. So yeah, but this hearing is going to be great. It's going to be great. It's going to be crazy, great. Craked. Let's just make up words. Let's just hornswoggle it. You know what I mean? So, I love reading court documents though. Who is on the stand? Ezra all the time, man. She's done. She finished her time on the stand. There was a lot of good stuff. So, we went through a lot of stuff on there. I can't remember if you were there. I can't remember if you guys were there or not, because we had the ones, it's hard to tell, because I had the one where the internet went out, and then I had the one where I started it, but then there was no sound apparently for anyone, no one could hear me. Anyway, so it's hard to remember who was there because there was the false starts, if you will. But yeah, so it's not a long one compared to the others. But yeah, it finishes Ezra's time on the stand. She's done. And so with tomorrow, we will pick up with, there's some exhibits, some defense exhibits, but then there's defense experts. So it'll be interesting. And I have some other things in mind as well planned. So, but y'all, thanks for being here and learning. And we learned a lot, learned a lot today for sure. So y'all heard it first. If we do hear tomorrow from Judge, y'all heard it here first. But let's put the Sharkweasel. Sharkweasel can go back to the ocean. Bye, Sharkweasel. Okay. But you know what? Thanks so much for being here, guys. And thanks for being a squirrel. And I will see you guys hopefully tomorrow.